there is a correction. Container name of the container will be changed.
Give a fresh page.
My lord, this is hearing matter of
Chalo.
matter of 2022, your lordship.
এটা কোনটা দিলে?
To the goal. One minute, I am for the petitioner. That matter, Milord, whether
Where is Mr. Sonnal?
Sannal,
একটু পাস ওভার হোক।
মুশকিল হয়ে গেল।
State
টাইম not other. টেন দাও না, মেইন রেসপন্ডেন্ট সান্নাল সুবিধাকে চাইছি। আমার শুরু করা হয়ে গেছে, সব হয়ে গেছে। মাই লর্ড সুবিধা আছে।
পড়ে দিতে। অন্যগুলো একটু পাস ওভার কর।
Well, I don't find any rule, subsequent rule in this.
We take it up afterwards. Passed over.
মুশকিল হয়ে গেল। আপনারা বলবেন তো? আমরা তো বলবেছি তো আপনারা ঠিক আছে, আমরা তো বলবোই।
Item number 1 is passed over. You make your submission after Mr. Bhattacharya.
My lord, will kindly turn to page 61. I'll be very brief.
Yeah.
The objective is to ensure optimal utilization of available human resources by rationalizing the deployment of teaching, non-teaching staff.
আর একটা শূন্য দিতে হতো, আমি স্মরণে
কোনো ডিফিকাল্টি আছে? লোকনাথ ডিফিকাল্টি আছে নাকি?
না ব্রহ্মচারী কোনদিন ডিফিকাল্টি আছে?
Having surplus teaching, non-teaching staff to schools experiencing a shortage of teaching, non-teaching staff as indicated by a high pupil-teacher ratio. But this is the basic consideration. Then kindly come to scope. The SOP shall apply to all government-aided sponsored schools. I am skipping over. Shall cover teaching staff working in zero enrollment school. Therefore, there are teachers without in zero enrollment school also. Non-teaching staff working in zero enrollment school. Then 3 is important. Surplus teachers identified in schools where staffing exceeds the prescribed norms of RTE Act 2009. Then Lordship may skip over. Kindly come to me, Lord, Roman 7. Identification of staff for transfer. Lord, this is the area of concern for us.
Yeah.
All teaching and non-teaching staff posted in zero enrollment school shall be considered for transfer. Good. Teachers who are already placed on deployment may be transferred to the place of schools if required as per the PTR. Surplus teachers from other schools shall also be identified. Then problem and irrationality comes. For determination of surplus teachers of the school, teacher younger in age, younger in biological age shall be considered first. However, any willing senior teacher may opt for consideration. These two are contradictory. My lord is well aware, my lord, the entry into the service is knowledge dependent on the age. Somebody will not enter into service at a younger age than other one. And if you say that the biological age would be determining factor to consider surplus, then the senior teachers will go out, who may be younger in age. But the basic principle, my lord has a lot of experience in industrial matters and others. Surplus is based on the last come, first go. The person who has come last, he'll first go out. The same principle ought to have been resorted to maintain the balance and rationality. This is
The
basically
senior teacher will be transferred at first. Okay.
this last person who has joined the school, he should be declared surplus and go out.
Okay.
There is no question of biological age.
Okay.
But this is the area which really is troubling us. I am not going into detail of the others, which might be argued by my dear friend Shubhi Shannal, but this is the SOP, and kindly turn to page 53. Who is issuing this? The Commissioner of School Education.
Yes.
But he is an authority beyond the statutory provisions. The doctrine of dictation would automatically come. But that's a larger issue. I'm not going now to that. But here, basically, my lord was very kind enough to observe that that should be the norm. Last come, first go. We have no difficulty.
Okay.
Therefore, this part should be stayed.
And till this notification came up, what was the procedure that was adopted by the primary schools where there was surplus teacher and the teacher was
The
transferred?
council, I will show you that. The council was the authority to determine this. Now, Joshua,
2002 rule.
Joshua, boi dao.
Which book?
The 2002 transfer.
Boiটা বার করে দাও।
Column 1, my lord.
No, this spiral binding has been given this from this.
কি দেখাচ্ছিস বল?
That
Column এই রুলটা দেখা 2012
127
Page number?
transfer teacher statutory rules are there.
আর 104 start from
যশোকে দেওয়া আছে
104.
My lord, will turn to rule 5. I do not know the pagination. I am pressing the rule 5, which is followed by rule 4.
Mr. Biswas, please tell me the page number. This is 104 is
বইটা বার করে
separate.
দিন না। আর সুবিধা হয় Joshua হবে।
my lord your lordship kindly come to
কোনটা?
No, এখানে আছে,
হয়ে গেছে,
এখানে-
কোনটা দেবো?
sorry.
এটা Joshua পেয়ে দিন।
my lord 129
দেখ, তুই ওটা রেখে দেখো।
rule 5 দেখাচ্ছেন তো
Rule 3, 4, 5 তিনটে দেখো।
ওই provisor
appointing authority তো
provisor
এটা কি recruitment rule
No, transfer rule.
oh transfer rule my lord sorry transfer rules my lord
Kindly come to rule 3, rule strength of teacher.
No, it doesn't.
Well, got it.
Yes.
The primary school under the jurisdiction of the council. Therefore, the
141
authority is the council. Ordinarily, we'll have one teacher for every 40 people or part thereof, not being less than 20 in a hilly, 4-state or other thinly populated area. A second teacher may be admissible when the roll strength exceeds 60. A third teacher may be admissible when the roll strength exceeds 100. Similarly, a fourth teacher may be admissible when the roll strength exceeds 140 and so on. But this is the statutory norms formula deciding the roll strength. Then, what are the conditions of transfer? The council may, therefore the transferring authority is the council, may on its own motion or on an application from a teacher, transfer approved teacher within this jurisdiction from one primary school to another primary school, on the condition that such approved teacher is confirmed and has completed minimum 2 years of continuous service. But this will again be 45 my submission that it should be based on last come first go. Provided that the council may, if it considers necessary for proper utilization of service of a primary teacher, in the interest of education, transfer an approved teacher without maintaining any time limit of service. Provided further that where there is a surplus teacher according to rule strength, as stated in rule 3, the council may on its own motion transfer such approved teacher without maintaining any time limit of service by way of rational adjustment of teacher in a primary school,
উত্তেজিত মনে হচ্ছে
having deficit teacher in the following order of preference. Primary school without an approved teacher, primary school having single teacher, other primary schools having shortage of teacher. These are the basic conditions. How it is to be done? 5. A teacher seeking transfer under clause B of rule 4 shall submit his application for transfer with reasons thereof to the concerned sub-inspector of schools during the month of December of each year, and the concerned sub-inspector of schools shall subsequently send such application within specific views to the respective council by January or succeeding year. Subject to sub-rule 3, the council shall consider such application, take a decision in respect of transfer by February. Therefore, transfer must be made at the beginning of the year, academic year, otherwise it might disturb the entire thing. Then 3, the council may, while processing the application for transfer of approved teachers, consider the application of such teachers as stated below on the priority basis according to the following order of preference, namely, a physically handicapped, I'm not traveling my lot with this, these are not very important at this stage. Then, 4, after considering the application for transfer of an approved teacher, the council may accept or reject the application for transfer, and such decision of the council shall be final. If the application of the approved teacher is accepted, the council shall issue an order of transfer under the signature of the secretary. Therefore, these are the basic procedure for the purpose of transferring a teacher. Now the RT Act is come. RT Act also given away the ratio of teacher-student ratio. That is they call PTR. But the basic norm of transfer remains. That is governed by the statute. There might be a change of ratio, but that would not relate to the change of transfer policy. This being the position, here the SOP, which I have also pointed to your lordship, is really creating a chaos. A teacher who might have entered into job at the age of 35 because of his excellence in the exam, and someone has entered at the age of 39. Now, if you say biological age, the teacher who has entered earlier has to go out, which is the basic principles of being declared surplus. These are some for an interim stage.
Yes.
চলে যায়নি my basic submissions item number 5 and 6 that the so-called SOP ছোট করে বলতে হবে একটু না বললে হবে
3 and 4, who is appearing?
4, my lord, I am appearing.
My petition left.
You are adopting the similar submission?
He's senior to me. Let him complete class and I.
Yes, sir. Let Mr. Shannan and Mr. Ahmed complete thereafter.
হ্যাঁ এই রাইট টু এডুকেশন একটা কপি দাও
5 and 6, you are moving.
না মানে the so-called SOP
Just a minute, we take the 5.
বার করে নিয়েছি
কে?
না আছে
আরেকটা কথা না আমি আর্গু করবো কি করে
এটাকে ওই আগেরটা উনি যেটা মুভ করলেন তার ওটা এফিডেভিট অফ সার্ভিস
একটু বালুকে সরিয়ে এটা রেসপন্ডেন্টের দিকে দাঁড়িয়ে পড়েছি ওরা দাঁড়াতে পারছে না
ইয়েস
my learned senior has urged on the point of biological age or senior. I'm not going into that. I'm on other point to it. The so-called SOP issued, your losses will get it at page 164, and your losses there are two, first and revised, 164 and 166. Now I take your losses to page 163, by which this was communicated to the sub-inspector of schools by the chairman, North 24 Parganas District Primary School. Well, this petition relates to District of North 24 Parganas, but the submissions will, I think, will cover the all. Well, kindly will look at this. With reference to the subject mentioned above, there must be a word missing. You are also requested to go through the enclosed vacancy list and revised SOP regarding the rationalization of primary teachers under the North 24 Parganas DPSC and collect the transfer applications in the attached pro forma from the schools having surplus teachers, maintaining the revised SOP as per the following schedule. This is the first part. They are asking to follow the revised SOP. Then your lordships, from willing senior teachers of surplus within 31st July 2026, that is over. From junior teachers of surplus teachers within 6th August 2026. This is our urgency. This is going to happen, my lord, by 1 day or 2. Then your losses. All sub-inspector of schools are requested to send the revised transfer application from the zero enrolled, temporary posted, and willing surplus teacher as per first SOP within today, and send the remaining revised transfer applications as per the revised SOP along with the given Excel sheet as forwarding note or recommendation on the very next working day of each timeline mentioned above. My lord, this is absolutely contradictory. They are asking the sub-inspector schools to follow both fast and, my lord, the revised. The basic thing, my lord, I will be urging if you losses kindly come to page 61, the so-called SOP, 164. My lord, at the basic submission, this is not issued by, my lord, I do not find anywhere that this is issued by the government. My lord, if it is under Article 162, this must be in the name of the governor. Or otherwise, simply this is an administrative instructions. Kindly look at losses, you will not find anywhere. Who issued it?
There is no signature of any.
No signature. Page 64 ends at page 65, and then whatever, and then revised page 166 ends in page 67. So at best, my lord, one can describe it as administrative instructions. Now the point I am urging, can the administrative instructions violate the provisions of the Act? I will show that. Your lordship, before that, kindly come to page 164. Scope. Scope, your lordships, kindly see. Surplus teachers. Roman 3.
Yes.
164. Surplus teachers identified in schools where staffing exceeds prescribed norms of RT Act 2009. So they are asking, follow the RT Act 2009. My lord, in the revised SOP, this has not been changed. This is the same. Page 166. Both the same, your losses. Only, my lord, D, clause D was changed as, my lord, senior Mr. Bhattacharya are good on that. Now, I take your losses to the RT Act now. Just a copy of it.
RT is here.
RT is there.
Schedule.
Yes. Well, 49. 49 starts.
Yes.
Now, my lord, kindly consider section 25 first. Then schedule. I will take your losses to the schedule.
Yes.
My lord, subsection 1. Within 3 years from the date of the commencement of this act, the appropriate government and the local authority shall ensure that pupil-teacher ratio as specified in the schedule is mentioned in each school. Clearly, losses? My lord, here the teacher has not been defined in the act. Your losses will not find it. Only one thing your losses will find that in the schedule, your losses kindly come to the schedule of the act. The schedule of the act.
Final mala 44.
এখানে কোথায়? কি একটা দিন?
Yes.
Just a minute. কোথায় রেসিপি কই? Now your losses kindly see. Schedule mentions sections 19 and 25. Then your losses. Number of teachers from 1st class to 5th class. Admitted children up to 60. Number of teachers 2. Therefore, if I go by the letter of the act, it refers to school. And admitted children up to 60, number of teachers 2. Admitted children with reference to school if 60, they will consider 2 teachers, not more than that. If there is a 3, he will be surplus. They have exactly done it. But that's not the meaning of the act. Why I'm telling you, Lord, I've given the examples in my petition. Now, suppose, my lord, This is not a suppose, your lordships. Exactly fact. In our West Bengal, up to class 4 is the primary teacher. From this year, from class 1 to 4, pre-primary to 4, 5 classes. Now, from this year 2026, 5 has been also included. Therefore, there is 6 class. But I put a question to myself. 60 teachers, there are schools, in one class 5 students, one class 10, another 20, another 5, again another 10. It goes to 60, but they will give 2 teachers, others making surplus and transferred. Then who will take the other classes, my lord? Clear to your lordships? If we go by this, therefore this is not referred to school, this refers to class.
Each class should have 2 teachers.
Exactly, my lord. Is a class, no, up to 62, that means 3, 30, 30 is to 1. 30 is to 1. Then your losses kindly see between 61 to 90, 3, that means 30 is to 3. Then you'll between 91 to 120, 4, 30 is to 4. 120 is to 4, and 30 is to 1 each. Then between 121 to 200, 5. And then your lordships, if the student strength goes above 150, then there will be 1 head teacher, not before that. But in our state, there is no assistant teacher in the school, even only 1 head teacher. I will give the example. Now, therefore, my lord, head teacher, they are not considering in the SOP as surplus teacher. But a school under the RT Act cannot get a head teacher before 150 students. Kindly, your lordships, for a moment, kindly look to the, my lord, SOP at page 165. Starts with 164. Kindly have page 165. For at the very top, your lordships, F, for primary school with low PTR, the concerned HT would not be considered as surplus teacher for transfer. Therefore, my lord, in a school where there are 3 teachers, 1 head teacher, he is not being considered. But under the RT Act, you can't get a head teacher. Then why do you not consider the head teacher as the surplus teacher? Then your losses, kindly again take your losses to the schedule again. Above 200 children, pupil teacher exceeding head teacher, excluding head teacher, shall not exceed 40. Therefore, my lord, if a school have 200 students admitted, their ratio will be counted 40 is to 1. But this is not mechanical, my lord. Suppose class 1 gets only 20 students. Class 1 get 1 teacher. Class 2 gets, my lord, 60 students. Even then, my lord, then there will be a section. 40 is to 1. You can't exceed 40. Therefore, that particular class 2 has to be divided in section, as we used to get in our schools. Then third class, my lord, suppose 10, again 1 teacher. Fourth 20, again 1 teacher. Is go like this if you apply it. But if you consider with reference to school only, then there will be no teacher in certain classes. I will give example to that, your lordships. I've given. Before that, my lord, I take your lordships to the our act and rules. Our act means state act. State act rules work. Then I will take to the example. Rules. এখানে তো হবে না। This is not recruitment rules. I take your losses, kindly take up the recruitment rules.
My lord will find action 129. It starts from, my lord, 127.
127.
Yes.
Well, this is the recruitment rules. Well, kindly have your losses, page 128. Head teacher has been defined in sub rule J. Head teacher means the teacher of a primary school appointed as head teacher of the primary school by the council in accordance with these rules. This is the definition of the head teacher. Malad, RT Act has not defined who is the head teacher. Then your loss is O. Teacher means a person who holds a teaching post in a primary school or in a junior school on a regular and whole-time basis, is paid either wholly or in part from the funds under the control of the state government in education department. We have no difficulty with this, your lordships. Now, our difficulty, your lordships, kindly consider Rule 14. The council
Yes.
the council shall appoint head teachers in every primary school within the jurisdiction of the council. Well, it doesn't consider the number of admitted students. Kindly consider the RTS schedule. Before 120, you cannot. But in our state, there are head teachers in every school. There may be a vacancy because there is no recruitment, all that. But law postulates there must be a head teacher. Now, what will happen when there are a head teacher in the school? Will you not consider him as assistant teacher in case of below 150? This is a contradiction between the State Act and the Central Act. Central Act must prevail in case of repugnancy.
What does the SOP says that head teacher will not be considered for surplus?
Exactly. Kindly see page 165. For primary school with low PTR, the concerned HT would not be considered as surplus teacher for transfer. Low teacher means deficit, where students are less, but teachers are less. No, low with low PTR, people teacher ratio. But teachers exceeds the ratio of students. That's the low PTR. Except. But in other cases, you will consider at what stage, because the state Central Act says before 150 you cannot. Now I take your lordships to the examples I have given at page 131 of the petition.
Yes. Paragraph number?
Paragraph number 8. Class-wise definition to dewa hai. Now your losses will find Satyendranath Bose City Free Primary School, Panihati Circle. Present strength of the students 213. Present strength of assistant teachers 9. Head teacher 1. This school is entitled to get head teacher under the RT Act. Now your lordships, number of surplus assistant teachers 3. Now if your lordships go by the general theory, 30:1. If it exceeds 240, now my lord, there are 9 teachers. They have said 3 teachers surplus. On what basis? There are 6 classes. Every class must have 1 teacher at least. Now this is more clarified. Room number at a time, simultaneous 2, Roman 2. Madanpur SS Free Primary School, Amdanga Circle, page 132. Has you got it? Present strength of the students 39, below 60. This is a glaring example. Kindly see the class-wise strength. Pre-primary 8, class 1 12, class 2 5, class 3 6, class 4 8. This year 5 has been introduced. So they didn't get any class students. Now the present strength of assistant teachers 3. Head teacher already there 1. Number of surplus they say 2. Then if your losses go by this, there will be only 2 teachers and the other classes will not get the teacher. I have made myself clear to your losses my analogy or the examples, how they have acted contrary to that act. The other classes can't have any teacher. Then kindly see, my lord, Deepkola Free Primary School, Amdanga Circle. Present strength of the students 65, just above 60. These are 2 glaring examples, your lordships. Class-wise strength, pre-primary 14, class 1 14, class 2 13, class 3 11, class 4 13. Present strength of assistant teacher 3, head teacher 1, number of surplus assistant teacher 1. They go by with reference to school. Your losses kindly consider the schedule. They say this is 69 above 60, you are entitled to 3. They do not consider about the class. What will happen to the class?
Okay.
Then I don't know whether they will jump up and say that one teacher will take 2 classes at a time. I don't know, my lord. If this is their case, then my lord, everything should go. These are young students, hardly my lord 5, 6, 7 years. On what basis they are declaring surplus? They are saying RT Act, they have declaring surplus. Kind level look, Roman 3 school, Deepkola, 65, above 60. If your losses, kindly take the schedule once. Your losses, it will be clear to your lordships. শিডিউলটা নেই কেন বুঝতে পারছি না অদ্ভুত তো একটা পেজ বাদ দিয়ে দিয়েছিস নাকি
3, there is no surplus. As per schedule, there is no surplus.
No problem. But if I go, because your losses top of the school, norms and standard for a school, top. So this should not be, malad, one should not read the law by the letter of the law, by the spirit of the law. I will take your losses to the further provisions of the RT Act. This should be redundant. The entire act will be redundant. Then 2 classes teachers will just play. They will not have the classes because the other class is not, so long the other class is not ended. If the other class is ended, that teacher goes to another class, those students will sit idle. How can it be, my lord?
Okay.
Then your losses. The other thing I take your losses. Your losses will find now 4. Balugai Free Primary School, Banipur, present strength of the student 103. Present strength of assistant teachers 2. Head teacher 1. Number of deficit assistant teachers 1. But I have not been able to give the details of the distribution of students as per class wise. But here your losses, kindly see the deficit 1 according to them. Now your losses will find Rajballabhpur Junior High School, 340 students, 13 teachers. Head teacher nil. There is no head teacher. Number of assistant surplus assistant teachers 3. They go by the schedule as they read. Again, they do not apply their mind while they issue the SOP. How they do the declare the surplus teacher? Surplus teacher 60 students. There are 4 teachers, 2 surplus. Go. They do not consider that there are 4 classes. 60 students is distributed amongst the 4 classes. Then 5 classes. They can't get the teachers.
Yes.
Now, other thing I take your losses to the act. Now, kindly consider section 8. Duties of the appropriate government. Matlab, here appropriate government means with reference to school under the definition clause state government. Is it not a central school? Matlab, had it been a central school, central government. The appropriate government shall provide free and compulsory education to every children. Matlab, I'm not taking into that. I'm only if matlab, provide free and compulsory elementary education to every child. Now, if I go by their calculation or their method of surplus, matlab, there are two. In the given example, there will be no teacher for 2 classes, 3 classes. How they teach?
Okay.
Then your lordships kindly consider D, clause D of the same section. Provide infrastructure, including school building, teaching staff, and learning equipment. Matlab, we have to read the act with the object to provide free and elementary education to all children. So it is your duty to provide sufficient teachers to each class. You can't read with reference to school. Then this will be nugatory. The entire act would be nugatory. Then your losses kindly consider duties of local authority. The district primary school council is a local authority under the act. Again, your losses, section 9, small a. Provide free and compulsory education to every child. And then, again, your losses will find F. Provide infrastructure. Infrastructure includes building, teaching staff, and learning material.
Yes.
Now, I take your losses to the schedule again. কোথায় রে শিডিউলটা আমি কেন খুঁজে পাচ্ছি না বলতে পারবো দেখি দেখি তারপরে প্যারাগ্রাফটা বাদ করো। Now your losses will find norms and standards of school. Serial number 1. 1A I have placed before losses. 1B. Matlab 2 building. I am
Come
placing
to-
2 building.
Come to section 19.
19. 119.
Yes. 19 days of school.
Yes. No school shall be established or recognized unless I have taken this point in petition. I will take your losses to that.
Okay.
But the schools are recognized government school. Government school in the sense is an aided, fully aided school. All primary school in the state of West Bengal, my lord, in the rural areas, all rural areas under the district council are aided. There might be very, very few. In the metro city, my lord, we get private schools recognized by the board. But in the rural area, all schools are aided schools. That's your lordship's very schedule also refers to section 19. And that's my point, your lordships. One has to read the act as a whole. So you provide infrastructure, you class-wise teacher. My case is class-wise teacher you have to give. You can't declare surplus like this.
Okay. Continue. Yes.
Now your losses. Schedule 2. Schedule item number 2. Building. Kindly see. All weather building consisting of at least one classroom for every teacher. I pause here for a moment. But according to me, it concedes what I submit before your lordships. At least one classroom for every teacher. Because in the primary school, 1 to 5 classes. So each class have a separate room and each class have a separate teacher. Kindly consider with this. building, this clause, your losses, I request your losses to read with one number of teachers from first class to fifth class.
So if it is 60 and 2 teachers, you say that there has to be 2 sections consisting of 31. First clause of
First
schedule
clause, admitted children up to 62.
2. So as per you, it will be 2 sections.
I beg lordships.
As per you, it will be 2 sections
No,
consisting of 30.
what I am saying, 2 sections not. Up to 60, if we read with losses with the first class to fifth class, 60 students may not be in one class, cannot be. There are 5 classes. So this has to be divided, consider what are the strength of the 5 class.
Yes.
That I have given you losses, the example paragraph 8, Roman 2, 3. The class-wise breakup. Okay. No, if the ratio covers above 40, then there will be 2 sections. Okay. Otherwise, in a one class, class 1, if the number of students becomes 41, then there will be 2 sections. Am I clear to losses? Because why this is done? Because a teacher cannot manage more than 40 at a time. Because they are nascent students, young. They will, at the time of teaching your losses learning process, they will play also. So they have to manage. One teacher cannot manage more than 40. Why this ratio? They cannot teach them.
Yes.
Then your losses, if we read it, your losses, what does it mean, Malad? It takes us to the meaning that 1 to 5 are the primary teaching. Still, up to 25, this was 4, now 5. So there must 5 classes. So there will be each separate classroom for one teacher. That means, the act itself conceives with reference to class, not with reference to school. Now I have given you losses, kindly consider. Page 139, paragraph 26. I have given example, Malad. My submission is not in vacuum.
Page 139.
139, paragraph 26. If, small if.
Yes.
May I read out? As already stated herein before, that there are a considerable number of primary schools in the state where at least separate one classroom for every teacher does not physically exist. For example, Akola GSPF High School, Banipur Circle, Banipur area is very well known to us because several, reputed persons of our country has come up from this Goburdanga, Banipur. Banipur has a training teachers institute, very old. Here, a particular school where 3 separate classrooms exist. And in one classroom, 2 separate classes are held at a time, sitting the student facing opposite sides. Can you imagine your losses? One can imagine it. But one classroom is shared between the 2 classes. Like this, I am looking at this, they are looking at that. And sometimes with a porda. And you do not consider about the infrastructure. You are concerned with the declaring surplus teacher and get them transferred anywhere you like. What will happen to the school, my lord? There are a number of schools. Because it's not possible, because of paucity of time, otherwise we could have given the full data to your lordships. Because they will give the transfer, make the transfer tomorrow or day after tomorrow on the basis of this declaration of surplus.
Yes.
So these are the factual thing, your lordships. Now your lordships will find the age, your lordships, I have given what my learned senior friend has elaborated. আমরা একটা কোথায় এক্সাম্পল দিয়েছি না ওই যে age my lord, I often your lordships, my lord, deals with the now Now, your losses, there are in the primary section, there was a recruitment in 2016. 32,000 teachers recruited. Now, thereafter 20, 22, 25, it's not yet. Now, X, a very good student, he appeared in 2016 recruitment process, got selected, got appointment in 21 at the age of biological age of 21. Why is not such a good student? He cracked it at the third attempt in 2022. But his or her age, biological age, much more than me. Crude example, often we come up because of their delay. I could not be appointed. Give me notional benefit at 50, area 50. I'm not taking that. Now that candidate is not to be considered for surplus because of my young age. I will be considered. Then merit becomes a sin. Since I got the appointment first on the basis of merit and my biological age is younger, then I should be transferred first. What is the logic, my lord, behind it? I will take your losses to the logic they have given in the SOP, so-called SOP. Now the
I put this question to Mr. Bhattacharya also. All these years, what was adopted by the primary council when you say that there is surplus teacher?
only on the basis of the number of students, not with reference to school. That's their rules also.
Anybody can be transferred of these. Suppose there are 4 teachers, one is surplus as per calculation. So who goes out?
The last person who joined. The last person who joined in the school will go.
But the rules is not specific about each of the persons.
Not specified.
Now the SOP comes up with this specifying that
SOP initially joining, subsequently they changed biological.
yes.
Initial first SOP says who joined on the senior in joining, but the revised says biological. Now this will be continuous effect, perpetual. If I am younger in age, always I will be surplus wherever I go. Kindly consider, visualize your losses. I got an appointment at the age of 21. My learned friend got at the age of 30. We are in the same school. I am transferred. I am going to another school. I will be again, because of my younger age, 21 there. And in the near future, again I will be surplus and I will be again transferred.
Yes.
Now, kindly consider, I have given an example. Page 140-26K.
120?
Page 140, paragraph 26, small k.
Yes.
As per clause 7, small d and f of the revised SOP, for determination of the surplus of teachers of a school, teacher younger in biological age shall be considered first as surplus teacher. The basis of biological age for determination of surplus teacher of a school is wholly illegal, arbitrary, malafide, and unconstitutional, for being violative of Article 14 of the Constitution of India, inasmuch as the petitioner number 87, Miss Dibomita Pal, whose age 34 plus, year of birth 1992, has joined Satyendra Bose City Free Primary School under Paniyati Circle on 13th February 2017, whereas the teacher who is senior in biological age joined the same school subsequently in the year in 2021. Malad, I could have given the name also, but they have avoided giving the name because they are all colleagues. Somebody will be affected, so they avoided the name. But there is at least 3 teachers. There are 5 teachers in the same school who joined in the year 2023 and 2025. But Mrs. Debomita Pal becomes surplus teacher for being younger in biological age. and other 6 teachers do not become surplus for being senior in biological age, though joined much later the same school in point of time. But here the another point comes up. On the basis of merit, I got this school. Kindly visualize the recruitment rules. Counseling does on the basis of merit. Choice was given which district I choose. This is within the district, no doubt. But the choice of school on the basis of counseling, the merit is compromised then. Selection was done. Why? How could you transfer me like this?
Oh.
They do not consider anything, just give the SOP. So these are my primary submissions for the interim order because they will give it on 6th August. Oh, another year of 16. I do not know, my lord. What I give you losses one more thing. 176. Oh, you can borrow. 176. Lord, if your losses kindly come to page 176. Page 176. It's a permanent no. Aim. Lord, this is very relevant for the present moment. Page 176. My lord, this is issued on 10th July 2026. Director of Census Operations and Chief Personnel Census Officer, West Bengal. Kindly see, my lord. This was addressed to the Special Secretary, Nodal Officer, Census, Government of West Bengal. Census 2027 activities in the state of West Bengal is going on full swing. It has been observed that the inter-district transfer of officers and officials are continuing in several districts, including those who have already been trained and deployed as master trainers, field trainers, enumerators. Malad, we are enumerators. We are under this central government has appointed as enumerator. All primary teachers are enumerators. Supervisors also. Some of them senior are supervisors. And other census functionaries engaged in census work. As census is a systematic flow of knowledge and work, such transfers are likely to be adversely affect the availability of the trained manpower and may hamper the progress of effective implementation of various census activities and timely completion of first phase of census 2027. In view of the above, it is requested to issue necessary instructions to all the concerned departments to avoid such transfer of officers and staff presently engaged in the census work until the completion of first phase of census operation, that is to say, house listing operation scheduled up to 30th May 2026. Namalad, I am a teacher of a Panihati circle. Namalad, I am transferred, for example, Beganga circle. 100 meters away. Then how do I perform this? Within the district. Then how do I perform this? Census Kamalad duty I have to do after completion of my school duty. I have to do both. And I have, because I have been enumerator in a particular zone.
Which paragraph you have stated that you have been appointed as enumerator? All 87 has been appointed. All
primary
87
teachers are taken.
all 87 petitioners are enumerators.
Paragraph 28, page 143.
Oh.
Well, I could have come up with much more better examples, but because of paucity of time, I could not prepare. If I give you losses the data, the entire act is against the right to education. Entire act of this. Now your losses, there is a I've given just my lord on the, because for interim purpose may not be necessary. Now, in terms of the my lord, direction of the Honorable Supreme Court, there must be a special educator in every school. What is special educator? My lord, those are specially educated to teach the special needed students. CWNS. They are called my lord, CWNS. Now, my lord, their duty not only to teach those 2, 3, 5, 4 students, their duty also to teach the regular students. So they are as good as assistant teachers, but they are not taken into consideration.
না তাদের মধ্যে ঢুকিয়ে দিয়ে করে ইচ্ছে তাহলে তো ওই স্কুলটা তো ওখানে থাকবে মানে অফকোর্স হয়ে যাচ্ছে 2009
Yes.
I have prepared, my lord, but I will, for the interim purpose, that this is a, my lord, at best an administrative instructions. This has not been, this is not an, my lord, an executive order, even under the, my lord, under the constitution, under article 162. কোন প্যারাগ্রাফটা বলবে আমি না দেখে বলে তাহলে বলবো না প্যারাগ্রাফ নোট করিস নি কেন বলে দিই যশোরকে দেওয়া হয়েছে Lord, I am opening the paragraph also. Paragraph 52. মিলবে তো? So kindly consider this. As a result of the above discussion, we hold that judgment ওকে বলো
2009
দিচ্ছি দাঁড়াও
15
ভাবলিও না
705
আসলে এতদিন তোকে আমারই ভাবতাম তো তুই ওইদিকে চলে গেছি বলে তোকে ভাবতে পারছি না
2009
Paragraph 52. As a result of the above discussion, we hold that the notings recorded in the official files by the officers of the government at different levels and even the ministers do not become the decisions of the government unless the same is sanctified and acted upon by issuing an order in the name of the president or the governor, as the case may be, authenticated in the manner provided in articles 77(2) and 166(2) and is communicated to the affected persons. The notings and decisions recorded in the file do not confer a right or adversely affect the right of a person, and the same can neither be challenged in a court nor made basis of seeking relief. Even if the competent authority records nothing in the file, which means that's a different aspect. I am on the proposition, if it becomes a law only when it is issued in the name of the governor. Otherwise, it simply becomes an administrative instructions, and that too here your losses will not find who issued it.
এটা বললেন এনিথিং ন্যাশনাল পলিসি
আমাদের কপি করি I just will not give every outlines because for the interim purpose Malad, this is National Education Policy 2020.
Yes.
Now, Malad, my learned friend appearing for the other side can enlighten your lordships to this, because so far my knowledge goes, your lordships, this National Policy 2020 was not being adopted by the earlier government. Admittedly. Because, my lord, education is in the concurrent list. State can also frame law. But in case of repugnancy, central law will prevail. That's the settled law. So this was not being adopted. Now your losses will find now your losses will find page paragraph 2.3. আমরা কোন প্যারাগ্রাফে বলেছি বাট আচ্ছা এখানে কি দেখাতে চাইছিলাম জানো এখানে কেন দেখাচ্ছি এটা? হ্যাঁ সেটা আছে, এটা কেন রেফার করছি? ট্রান্সফারের সঙ্গে কি? मतलब kindly consider first paragraph 23
23
para 2.3
of
2.6 2.3 and 2.6 of this national education policy. 2.3 first, teacher vacancies will be filled up at the earliest in a time bound manner, especially in disadvantaged areas and areas with large people to teacher ratios or high rates of illiteracy. Special education attention will be given to employing local teachers or those with familiarity with local languages. A people teacher ratio under 30:1. Kindly consider your losses. 30:1. Every 30 students get one teacher. That's the national policy. Exactly the RT Act. Except RT Act says in case of 40, above 40, you will get another teacher. Very logical. Because a teacher cannot teach more than 30 at a time. But for 10, another teacher, no. After 10, 40, you will get another teacher. Will be ensured at the level of each school. But these with reference to class, cannot be with reference to school. Then suppose a primary school have 30 teachers in the 3 class. There is no matter 1, 2, and 3 class. 4 class doesn't exist probably in a new school. Then only one teacher will teach class 1, class 2, class 3. Can it be, my lord? Law cannot be, my lord. Absurd. Areas having large number of social economically disadvantaged will aim for a PTR of under 25:1. Kindly consider. If there are the socially backward area, you must consider below 20, 30, 25. Because more attention has to be given to the students. Teachers will be trained, encouraged, and supported. Then your losses, kindly see. 2.6. A national repository of high quality resources on foundational literacy and numeracy will be made available on the digital infrastructure for knowledge sharing, DIXA. Technological interventions to serve as aids to teachers to help bridge any language barriers that may exist between the teachers and students will be piloted and implemented. All the teachers are now getting this knowledge through DIXA, through the portal, digital portal. We have stated it, your lordships. Paragraph 29, 30, 31 and 32.
এটা অ্যাডাপ্ট করছে, এনইপিটা অ্যাডাপ্ট করছে, ইউনিটের তাৎপর্য
yes.
এটা আমাদের
So therefore, again, my lord, the declaration of surplus against the 30:1 per class. So these are my submissions for the. Lord, we are asking for the stay of the both the SOP and the, my lord, the impugned letter, and do your lordships.
Yes, both the SOPs are applicable. If a revised
That's what they have to say, because later your losses kindly see the impugned letter. That's at page 163, last paragraph. Within 2 days, that means 30th July, first SOP, and then revised SOP.
you have gone through the SOP, the only difference is that of clause D of clause 7.
Exactly, biological.
The other
Otherwise,
clauses are there.
Otherwise, and the other point, my lord, kindly consider this. It is their case, your lordships, that who is issuing this, my lord? Page 163. Chairman. Well, there is no council. Let's be free, losses. There is no council throughout the state. And in other communications, I got chairman in charge. Now the DI is the chairman in charge.
At present, chairman.
Chairman in charge. Under the law, DI is the secretary, ex officio secretary. Now one person becomes the secretary and the chairman in charge. How can it be, my lord? And drinking, there is no body itself. They are functions of issue.
ট্রান্সফার অলরেডি করে দিচ্ছে আমাদের প্রচুর লোক ট্রান্সফার করে
And other districts, my lord, it's
আমাদের
in,
ডিস্ট্রিক্টেও
they are started, my lord, transfer on this basis.
স্টে করে
You are in? Item number 6 to the.
My argument will be slightly different from the argument so canvassed on behalf of the petitioner. My lord, your lordship will kindly take the RT Act.
But I am in item 5 appearing for the state.
6,
It is all the same.
only 5.
The same.
How it is? Mr. Bhattacharya has argued in 2.
Since I see, my lord, that one
Then,
after
my lord,
another
keep
the
there.
argument
My
is
lord, on a
not
lighter
being
vein,
made. For
if
this,
there can be stay, my lord.
but now it would be difficult for me to collate, my lord, the submissions
Well, I
of
tell
all
you,
the
lordship,
learned
my lord,
counsels together.
Because I was of the notion I did not inquire from the learned advocates who is appearing for the state. Because Mr. Singh appears for all the matters.
we have
So
served, we have
Mr.
served.
Bhattacharya has
We
made his
have
submission.
served. Affidavit of service, my lord. 6. All the DPSCs are there, I believe.
DPSC with regard to item number.
PSC বলার কিছু।
So we are the implementing authority.
You will make your submission with regard to only 6.
Not only 5.
But the notices have all been given to the state.
Not 2 to 5,
that should be
not
done.
since I was here,
Full
but I
copy.
can make submissions in 2 to 5. Now, in so far as 6 is concerned, my lord, I
Fine, then who has been allotted with item number 6?
Well, I tell you, your lordship, the question of law is same.
You can,
My lord, I will only argue on questions of law.
but
let him make his submissions, you make
But
your
I'm handing over your lordship a copy of the Mr. Singh, my lord. If my Singh, my lord, accept, my lord, I, here and now, my lord, I will.
Use the
My lord, it is Sipsong Banerjee appearing in behalf of the state, my lord.
He is
Junior
just on his
present,
way.
my lord.
He's just on his way.
Oh, appear
Because
in which item?
in item number 6.
Oh,
Oh,
appear
then you take note, let him explain.
Sipsong Banerjee.
lordship will kindly take section 19 and 25 of the RT Act. 19 lays down the norms and standards for schools. That the school has to abide by the norms and standards so specified in the schedule. 25 in fact provides for maintenance of pupil teacher ratio or PTR. Now, your lordship will kindly take now the schedule. May I just make my submissions at the very outset? I am saying that this entire concept of surplus teachers itself for primary school itself, other than the zero enrollment schools, is contrary to the schedule of RT Act. Why I say so? Kindly take my lord schedule once. Your lordship will find from the schedule for the first class, to 5th class, admitted children, number of teachers. So these are the headings. If it is up to 60, there should be at least 2 teachers. So my lord, if the number of students is 61, there has to be 3 teachers. If it is 60, 91 to, if it is say my lord example 91, then my lord the number of teachers would increase from 3 to 4. If the number of students is 121, then the number of teachers would increase to 5. Then, my lord, if the schools have an enrollment of 151 students, then apart from 5 regular teachers, they should have a head teacher. they will get a head teacher. So we will have 6 teachers in hand. The whole purpose for which I am referring to the schedule is that 1:30, this concept, this ratio, is only for the purpose of giving a kind of guideline that there cannot be, a teacher can only cater to the needs of 30 students, not anymore. It does not say that in a school, in a primary school, say for example, there are 40 students, it will come under the bracket of up to 60. Right, there will be 2 teachers. So the classes would have to be divided into, say they have 3-4 classes, 5 classes, 12, some 7, some 8. So classes would have to be divided accordingly. And the teachers would have to cater, the 2 teachers would have to cater to the needs of these 40 students in a class-wise manner. As we say, class-wise or standard-wise. Standard 1, class 1, class 2, class 3, class 4. Similarly, if a school has, say, for example, 70 students, there are 5 classes which are running. The number of teachers would have to be 3. So, it is not gainsaid by anybody that this 1:30 is a ratio which will be determinative of the factor as to the surplus of teachers. But in a school, for example, there are about 200 students or 201 students. In that school, there are, suppose, 9 teachers. Then obviously, it has to be seen that how many teachers are catering to different classes. In primary section, there is no subject-wise distinction. Lordship knows better than us. But in any event, this catering to classes and catering to the needs of children who are studying in different classes, for that reason, this yardstick of 1:30, it's a variable yardstick. Yes, the maximum limit is 30. But there is no minimum limit, because a class may have 10 students, a class may have 7 students. Will the school stop running for class 1 and run only for class 3 and class 4? I put the question to myself. It cannot be. This is where the concept of surplus teachers fail. And this is where, we find that this impugned, this SOP is a, what should I say, I've never come across this kind of, document, supposedly a document which has been issued by the government, in my entire career. Because, we all know, submissions have been made by Mr. Bhattacharya, Mr. Shanna, that how executive orders are to be issued. Shobita boleche, orders are. So, in any event, I will come to that a little later. So, what I am on today, now kindly compare this along with the SOP. I take the revised SOP. I take it, the revised SOP is the final SOP. Because any amended version would be the final one. I take it that this is the final. The argument which my learned friends appearing for the state would make, look, how are they prejudiced? They will be transferred within the district. But I am representing teachers who are working in primary schools in the district of Nadia and district of Birbhum. Now, statistically, the area of Birbhum is 4545 square kilometers. The area of Nadia is 3927 square meters. So, a person who is posted in a school for which he has opted during the counseling process, he may be transferred to a school 170-150 kilometers away. Same for Nadia, because the area is large. There is no division of district into other divisions so far as Birbhum and Nadia are concerned. So now I take your lordship to my next point is that yes, I come to that. There are prevalent Next point would be that there are prevalent transfer rules. By this kind of so-called executive fire, the transfer rules cannot be rewritten. The transfer rules were framed, amended in 2017. The transfer rules do not provide for this kind of arrangement. These transfer rules are statutory rules. Well, kindly take my petition for once. Just one couple of pages, I will take your lordship to. Kindly take, my lord, the transfer rules at page 50. These transfer rules of 2002, which has been amended, the recent amendment being 2017.
2021
2020, no,
এটা
sorry, transfer rules to 2020, so 2002. আর এইটা কি? এটা হচ্ছে
amendment
2021. I'm sorry, it's not 2017, it's 2021. So, the recent amendment being 2021. If the state government intended to, my lord, revisit, revise, or reformulate the transfer policy, when there is already a policy in the form of subordinate legislation, it is not open to the executive government in any form whatsoever to issue an executive order which is contrary to the transfer rules. This executive order is not a mere gap filling exercise.
Yes.
So, my lord, in that view of the matter, now, my lord, kindly take the transfer rules. The transfer rules provides for even transfer of head teachers. I think submissions have been made that there is no provision for transfer of head teachers so far as the SOP is concerned. So they exclude the head teachers from the operation of this SOP. In my respectful submission before lordship, that will be absolutely impermissible and would be squarely hit by the relevant provisions of the transfer rules 2002 as amended till date. Now, we are coming back to the nature of the instruction. Kindly take the SOP. Well, the SOP is interestingly doesn't bear any date. Well, I will stand corrected by my learned friends appearing for the state. And if I stand corrected, my lord, I will be relieved that at least there is some sense working in the system. So, my lord, now kindly take, my lord, standard operating procedure for transfer of teachers. This is 49C and D of my petition, the revised one. Standard operating procedure for transfer of teachers and non-teaching staff from zero enrollment schools and rationalization of surplus teachers. Now, zero enrollment schools, I understand, my lord. When there is no student, there is no point in, my lord, keeping teachers in those schools. Those teachers are required to be transferred and they have to be transferred. None of the petitioners before lordship, at least the ones whom I am representing, are working in zero enrollment school. Now, we will kindly take now F. Well, this is 7F. Well, first kindly take 5. Roman 5 procedure. Identification of schools with high PTR having deficit of teachers. Well, this again, my lord, this concept of high PTR, low PTR, my lord, this question of high PTR would definitely arise. The remedy or the process by which this kind of defect or this kind of, my lord, administrative anomaly could be cured is not transferred from the existing schools. It is only by undertaking a regular recruitment process, which may be in process, may not be in process. I do not know, and I do not want to make any comment. Now, modalities of transfer. Kindly take, my lord, now. For primary schools with low PTR, the concerned HT would not be considered as surplus teacher for transfer. Well, I put the question to myself, very interestingly, the concept of head teacher or, my lord, the inclusion of head teacher in the scheme of things arises for schools which are, my lord, having students more than 150. We may have schools where head teachers are also have been engaged in schools having PTR of having students or roll strength of 60 plus or 90 plus or 120 plus. Correct?
Even 10 plus.
Even 10 plus. So there is no rationality
Courage to stand in.
to retain these head teachers in the schools if the government is so concerned or deeply concerned with the fact of the high PTR. The rotation or the movement of teachers from one school to another school, as provided for in the transfer rules of 2002 as amended, do not provide for any discriminatory or different kind of treatment for head teachers. So it cannot be done. This is where this SOP is directly antithetic to the transfer rules itself. Now I come to the next part. As there is no specific subject-wise post of teachers in primary school for determination of surplus teachers of a school, teacher younger in biological age shall be considered first. There is no rationale. What we have understood, what we have learned over the years, your lordships have passed several orders in transfer matters. Yes, some kind of relaxation may be permissible when the service holder is at the fag end of career. Say 2 years of service is left, 3 years of service is left. Rules also permit so. But where is this kind of discrimination or this kind of classification being worked out by the administration? I fail to understand. And there is no basis for this kind of discriminatory treatment. Any rational classification, any classification to meet the test of Article 14 and 16 must have a rational nexus to the object sought to be achieved, which may be through executive order. I do not say that the state does not have power to issue executive orders. The power to issue executive orders, which is conferred on the state under Article 162, is coterminous with the power, with the legislative power of the state, which from time and again, starting from Ram Lavaya Kapoor, it was all held. Ram Javaya Kapoor, it was all held. Now, I put the question to myself with all humility, that what is the basis of this particular classification? Does it really, is this classification would achieve, or would this classification would achieve the objects ought to be objects for which this SOP has been issued? Object is rationalization, use of surplus staff. When the head teachers are of no use in some schools, like 37, having this roll strength of 37, 39. I've given it in paragraph 8 of my petition. Paragraph 8, na? 8. Petition. What is the purpose for retaining the head teachers? And what is the purpose for, treating, what is the language used? Biological age shall be considered first. So entry of service, nothing is relevant. It is the biological age which is relevant. And why is it relevant? It has not been spelled out in the SOP. Now, kindly come to E and F. First, the surplus teachers would have to submit preferences, 3 preferences, that is under 8 clause 8 small a at 49D. 49D. A.
7E.
7(8)(a). That identified surplus teachers shall be given an opportunity to submit their preferences from amongst the published list of high PTR schools within stipulated timeline. Now kindly come to clause E. Transferred orders shall be issued as far as practicable based on the options exercised and administrative requirements. If a surplus teacher, here the SOP my lord, acquires the character of mandatory nature. If a surplus teacher fails to submit preference within the prescribed period, or if the preferred schools cannot accommodate the teacher due to limited vacancies, the competent authority shall assign the teacher to any identified high PTR school based on administrative exigencies and educational need. Such allocation shall be final and binding. So, my lord, even if the teacher exercises option for A, B, C schools, and if the A, B, C schools say, no, we do not require this teacher for X, Y, Z reason, then, my lord, the DPSC being the, my lord, being assigned the duty of transferring these teachers, would have the liberty to place these teachers in, my lord, say EFG schools. And, my lord, that would be without any consent of the teachers, so, my lord, identified.
Yes.
Then, my lord, kindly, in the instance of, my lord, this is not relevant, my lord, zero enrollment school is done, that is all there. Now I come straight away to, my lord, some two judgments. First judgment I would be placing is Ghurinath. 97, 90, এটা নয়, এগুলো না। কেন দেয়নি? চলে গেল কোথায়? না দিকে চলে গেল? মানে, may I just place, I will hand up the copy. I'm so sorry, my lord. My lord will kindly pardon me. This is 1997 2 SCC 745. 97 2 SCC 745.
SCC volume
745. 745. My lord will kindly take note of paragraph 19. My lord, I will, my lord, my junior will hand up copies, my lord, at the conclusion of here. May I just read out the relevant portion? I'm so sorry, my lord. Well, by operation of Article 154, the executive power of the state shall be vested in the governor and shall be exercised by him, either directly or through officers subordinate to him, in accordance with the Constitution. By operation of Article 162, subject to the provisions of the Constitution, the executive power of the state shall extend to all matters with respect to which the legislature of the state has power to make laws. Thus, except these discretionary powers like that of appointing chief minister, the governor does not exercise any power in his individual discretion. The governor is aided and advised by the council of ministers appointed by him under Article 163. The executive power of the state is coextensive with that of the legislative power of the state, and the governor in the constitutional sense discharges the functions under the constitution with the aid and advice of the council of ministers, except in so far as he is by or under the constitution required to exercise his functions in his discretion. Well, then since this was the case of Jammu and Kashmir, they referred to, my lord, Article 370 of Jammu and Kashmir, which is now, my lord, done away with. Now, my lord, next, Placitum D. All the executive actions, judgment all the executive actions of the state government shall be expressed to be taken in the name of the governor as per the business rules of the government made in accordance with Article 166 of the Constitution and the business rules made by the governor under Clause 3 of so and so. The governor is the formal head of the state. He exercises all his powers and functions conferred by him or under the Constitution with the aid and advice of his council of ministers, save in spheres where the governor is required by or under the Constitution to exercise his functions in his discretion. The satisfaction of the governor for exercise of any of any power, other powers or function required by the Constitution is not personal satisfaction of the governor, but is the satisfaction of the constitutional sense under the cabinet sense of the system of government. The executive is to act subject to the control of legislature. The executive power of the state is vested in the governor as the head of the executive. The real executive power is vested in the council of ministers of the cabinet. There is a council of ministers with chief minister as its head to aid and advise the governor in exercise of his executive functions. So, my lord, my whole purpose is that this SOP does not disclose whether, my lord, executive power in terms of Article 162, read with 166(3) has been exercised or not. If the state says, now we will rectify, that cannot be done. The state has to answer that transfer orders have already been made, some transfer orders have already been issued on the basis of, my lord, SOP so formulated. I don't know whether it has been put up on website or whatever. It has been circulated to the respective DPSCs. So, my lord, an unsigned, my lord, unauthenticated SOP is being circulated to different DPSCs for its implementation
Not website, for what,
through WhatsApp.
WhatsApp group among the teachers.
And transfer orders are being issued on the basis of this SOP, which is, my lord, most irrational and even contrary to the provisions of RT Act, contrary to the transfer rules of 2002. Next judgment I would like to cite is, my lord, this is Paul Manoj Pandian to 2011 5 SCC 214.
আমি কপি করে দিচ্ছি, এটা
মানে
চলে এসেছে আমার কাছে।
I'm sorry, my lord. I will hand up the copies. I'm so sorry, my lord. Paragraph 47, 48, my lord. 2011 5 SCC 214. Once a law occupies the field, it will not be open to the state government in exercise of its executive power under Article 162 of the Constitution to prescribe in the same field by an executive order. Pausing here for a moment, the law in this field would mean, my lord, the transfer rules. However, it is well recognized that in the matters relating to a particular subject, in the absence of any parliamentary legislation on the said subject, the state government has the jurisdiction to act and to make executive orders. The executive power of the state would, in the absence of legislation, extend to making rules or orders regulating the action of the executive. But such orders cannot offend the provisions of the Constitution and should not be repugnant to any enactment of the appropriate legislature. Subject to that, these limitations, such rules, orders may relate to matters of policy, may make classification, and may determine the conditions of eligibility for receiving any advantage, privilege, or aid from the state. The power of the executive are not limited merely to carrying out of the laws. In a welfare state, the functions of the executive are ever widening, which cover within their ambits various aspects of social and economic activities. Therefore, the executive exercises power to fill gaps by various departmental orders. The executive part of the state is coterminous with the legislative part of the state. In other words, if the state legislature has jurisdiction to make a law with respect to a subject, the state executive can make regulations and issue government orders with respect to it. Subject, however, to the constitutional limitations, such administrative rules or orders shall be inoperative if the legislature has enacted law with respect to the subject. Thus, the High Court was not justified in brushing aside the government order. So, my lord, now, if we take the hierarchy of any legislation, at the topmost of the hierarchy would be, obviously, as your lordships have heard time and again, would be Constitution. Number 2 will be enactment. Number 3 will be any statutory rules or regulations made under the enactment. Number 4 would be, my lord, these kind of executive instructions or orders. Now, my lord, it so happens the executive rules or instructions or orders, my lord, these orders, if they violate my lord, the Constitution, here it violates Article 14 and 16 and 21 of the Constitution. B, it violates the statute in the sense, my lord, the rules have been made under the statute. C, it violates the rules itself, the transfer rules. Well, this executive instruction, if we take it as an executive instruction, this SOP, my lord, should be quashed. And in the meantime, my lord, that is the final relief I would be seeking. At the moment, my lord, the state should come up and explain as to how this particular SOP is in conformity with the schedule to the RT Act. B, how this particular executive fiat in the form of SOP could have been issued without being authenticated in terms of Article 162, read with 166(3) of the Constitution. 4, how the rulemaking authority, how the state government in its executive capacity could frame a SOP which is contrary to the rules without amending the rules. Lastly, my lord, the NEP, the National Education Policy, Mr. Sanal had made elaborate submissions on that regard. NEP is, my lord, now regarded as the primary document for administration of education throughout the territory of India. The NEP has been issued by MHRD, that is Ministry of Human Resources Development, Government of India. My lord, paragraph 2.3 of the NEP clearly provides that local persons should be preferred and should be appointed as teachers in primary schools. So, my lord, this is again, so my lord, today, if it is in conflict, my lord, if there is a conflict between this SOP on one hand, which is an unauthenticated SOP, and NAP on the other hand, being a document, policy document issued by the Government of India in MHRD, MHRD department, that is Ministry of Human Resources Department. Malad, the obvious answer, subject to my subject to your lordship's kind consideration, the obvious answer would be any provision made in NEP would prevail over this kind of unauthenticated SOP. So at present, my lord, my lord, all these states I am told, my lord, they have accepted the NEP. There are other issues, my lord, Mr. I do not want to, my lord, detain your lordship, my lord. We have detained your lordship for quite some time. So, my lord, I have formulated my points. But what I am praying right now, this SOP should be state. Did the state come up by an affidavit as to how this SOP is not contrary to the NEP and RT Act schedule and, my lord, the transfer rules.
Okay.
These are my, my lord, the judgments would be
hand you over within 10 minutes.
You are in which item?
Yes, very precise. Yes, all my esteemed seniors has made submission, my lord.
This is item number 3.
3.
P, who is appearing for the state in 3? You?
Mr.
Who has been allotted with
Piyush
3?
No, no. Piyush is for 5.
3 also.
No, 2 to 5 আছে
No, 3 also. 3 also.
Just
Mr.
three
Piyush Chaturvedi.
Mr. Chaturvedi appearing for just 5.
3 also.
Just
No, yesterday was Oh, Loknath. Okay.
Who is appearing for the state? You have served?
Yesterday you have served on Chaturvedi also, my lord. Oh,
Mr.
my lord,
Oh,
we have
Mr.
served
Loknath
upon
Chatterjee is appearing in item.
Vijendra Pratap Singh.
Mr. Loknath Chatterjee has given his name.
item 2, we have served notice upon state office of the land government as well as Mr.
In 1, 2. And in 3, who is appearing?
So therefore, 2 Loknath is appearing, as I have understood from them. 5 Mr. Chaturvedi is appearing. 6 I am appearing.
Vijendra Pratap Singh.
In item 4, my lord, as your lordship remembered
leading it?
yesterday, Mr. Vijendra Kumar Singh accepted service.
Oh,
So
my lord.
we have served Mr. Vijendra
No,
Kumar Singh.
Vijendra Pratap, we have also served on Vijendra Pratap Singh, my lord.
Okay.
He is appearing.
All right, you give us a copy. I will take care of it. Lordship, I will.
দাদা, আমি তোমাকে একটা copy
Affidavit.
Submission.
Affidavit of service.
Yes. And kindly take some at page 601.
এটা কোনটা দিয়েছো?
সার্ভিস করে
কি ছিল অপর্ণা মণ্ডল? শ্যামল কুমার। এই বার করে রাখো ঠিক করে না? 19720। এটা তো স্পোর্ট।
I know you maintain yourself. That is what. But he don't
Yes.
Page 60, my lord, the impugned policy, my lord.
60.
60.
Yes.
I'll be placing like 2 clause. Other clause has been already been placed by my lord's senior friends. Blood procedure heading clause 7. Identification of the staff for transfer. First clause. All teaching and non-teaching staff posted in 0 enrollment schools shall be considered for transfer. But here my submission is that imparting education is the fundamental duties of the state. For that purpose, schools are established and teachers are employed there. The object is to reach to every household to teach their, to ensure that education for all children. That's the whole object for establishing school and vis-a-vis employment of teachers. Now, in terms of RT Act and the rules framed thereunder in West Bengal, kindly takes up the rules. You should have West Bengal rules of RT. Now, this rule 4 of it's not there. Rule 4 of the West Bengal rules,
Transfer rules.
No, this is West Bengal right of children to free and compulsory education 2012.
That is not good.
I'll be handing over to Lashim the hard copy. What is the duty of the state and what they're actually doing? So rationalization of teachers for the purpose of education. For carrying out the provisions of this act of 2009 Act, the area or limits of neighborhood of a school within which school has to be established by the state government shall be. So it says mandatory duty of the state to establish school in respect of primary level. We are concerned with primary level. For rural area, 1 kilometer. For urban area, half kilometer.
Yes.
Then clause 2. The proviso is the provided that the state government may establish more than one school in the neighborhood of a school. Therefore, within 1 kilometer, state may consider establishment of more than one. Then clause 2 is relevant. Maximum number of student strength shall not exceed 300 in a school. For primary school and 500 for upper primary. We are concerned about 300. Therefore, within 1 kilometer, there must be a one school having 300 students. Now, that's the scope and object of the RT Act. Now, again, kindly turns to the policy. Just because there is no enrollment of teachers, students, you are transferring your teachers to other school. Instead of ensuring enrollment, I'll be placing judgments. In fact, we have placed that judgment before election in other matter, where court has held that before RT Act there was Sarva Shiksha Abhiyan scheme to reach to every student, every people in the area to ensure their education. Thereafter, RT Act was introduced and to bring those dropouts and those who are not even enrolled to the school. That special scheme has been framed under RT Act. While that regular teachers have been employed. Judgment may I just I'll place one paragraph from that judgment. Paragraph 17.
Judgment দিলে ভাই
বলুন আমি রিপোর্ট কোথায় তুমি নাম্বারটা
আনরিপোর্টেড হলে একটা কপি
রিপোর্ট করতেই দিয়ে দেবো রিপোর্ট হয়েছে
What is the citation?
possibly it was reported but it was reported in the AI and I'll be giving the citation below.
একটা কিছু দে না, দিলেই আমি বের করবো।
Like,
এটা তো
হুম, হুম।
এটা হলো আমি এসএসসি অনলাইন থেকে বার করেছি। এই কিছু একটা বল না।
এই যে এটা ভার্সেস কৃষ্ণেন্দু বিশ্বাস।
এটা আছে রিপোর্ট হয়েছে আমি দিয়ে দাও and kindly take some at page 24 first page 24 of the judgment this just above paragraph 10
সাইটেশনটা বেরোয়নি।
this paragraph starts with that as far as special training is concerned but just
Page
page 23
24.
last paragraph page 23 last paragraph
Yes, last paragraph.
state is under an obligation to provide special training by developing the materials for out of school children who have been admitted to their age appropriate classes but need their level of learning to be enhanced to the desired level of class to which he is enrolled. In this connection, the districts have already mapped the children and the schools and institution where special training will be imparted. As far as special training is concerned, the state has adopted the policy of engaging regular teacher for imparting special training in the regular institution. It is felt that special training is a specialized job which requires some level of basic educational background and experience in dealing with the hardest to reach the children. However, there is a fear that where the number of children is large, regular teachers may find it difficult to handle both regular class and special classes and may request some human resource in support. Well, this was my submission. Now, I'm at paragraph 17.
Yes.
There is no dispute that this is observation of the court. There are no dropout students. The issue of dropout students continued to prevail in the country, preventing many children from attending schools due to mainly engagement in domestic work in support of their families, lack of interest in studies, and sometimes, especially difficult for the girls to continue study because of the concern about their safety and sanitary problems due to poor infrastructural facilities. To carve out such problems, state should provide efficient and sufficient infrastructure. Apart from that, state shall also set up an alternative and innovative schools education as well as to bring back them to have education. State can involve those Shikha Mitras to educate them and or also inculcate awareness amongst the dropout children and their parents so that children may attend schools regularly for having education. Then only actual object of SSA and RT will be fulfilled. Therefore, admittedly there was dropouts. So when school doesn't have students, that cannot be a ground for transfer. Rather, the object is to bring those children into the school. Now, this is one. Second, limb of submission is and is already submitted that there is no executive order since it is not issued in the name of governor. Now, my submission would be that if you
There is
kindly
a
take
policy of the government where the number of students are less than 20. That is closed down. Is it by way of any administrative order that those has been closed? Because your submission is that the extent As far as possible, the number of
But if
students
I'm
should
not
be
mistaken, that
maximum.
possibly it's a policy of 2012, possibly. Now that is not contrary to the statute of 2009. Now kindly takes up the rules, transfer rules of 2002. First line of this notification, that it was issued in exercise of power under section 6. That's the rule framing power of the state.
Transfer rules.
Transfer rules. Under section 106 of the
106, yes.
in exercise of this power, the rules were framed.
Yes.
Now, transfer policy, it's very specific in clause 4 and 5 of the rules. Ground of transfer as well as the mode of transfer has been specifically provided therein. Now, my submission would be that when statute has been given power to frame rules and that rules is existing, having statutory force, there cannot be any executive order in that field. The submission made by my learned friend is that it is not an executive order. My submission is, even if I assume that some executive order has been issued in the name of governor, my submission would be that that executive order cannot be issued, since the field is already occupied by an rules framed in exercise of power under the statute. And there is a procedure prescribed. If you kindly takes up the rule Act, 1973 Act.
But in order to implement the rules, there are certain executive directions issued from time to time.
Administrative
Yes.
directions.
Yes.
That cannot contrary to the rules prevailing.
But then if a executive order is issued like this,
This is an executive order.
meet a situation in order to comply the RT 2009 and have a rationalization of that. So where is the difficulty? If there is a zero teacher, the teacher is not utilized. So they have framed a SOP for transferring that teacher so that his services can be utilized in different schools having deficit in number of teachers.
May I place the rules policy once again, whatever they are, which has been impugned here is kindly see the page 60 once again.
Yes.
Scope, rather objective, to ensure optimal utilization of available human resources. That's what has fallen from lordships. By rationalizing the development of teaching and non-teaching staff through the transfer of personnel from zero enrollment schools and schools having surplus teaching and non-teaching staffs to schools experiencing a shortage of teaching and non-teaching staffs as indicated by the high pupil-teacher ratio, then scope, if you kindly takes up clause 3, surplus teachers identified in schools where staffing exceeds the prescribed norms of RT Act 2009. But in fact, this policy has been framed to reach to the objective of 2009 Act. I believe there is no dispute on this. Now, the scope of RT Act is to educate everybody. Now, therefore, that's why I have referred 2012 rules to demonstrate the object is to reach every village. Now, to reach every village, rules framed under RT Act specifically provides for establishing schools within 1 kilometer. And that matter is not to end there. It also provides for the pupil must not be exceed 300. Therefore, if the state want to transfer all the teachers from a particular schools, state has to come forward with a survey that in this village there is no students for the purpose of imparting taking education from that schools. That is not the case of the state. You did not establish school. You could not bring those dropouts into the school. That was your statutory mandate. Instead of complying that mandate provided under the statute, and that is a central statute, state you are bringing a policy which is in fact contrary to the policy of the 2009 Act. That is my submission.
Okay.
অগ্রতা বলেছি। And this RT Act provides for this number is a bare minimum, that it does not exceeds that. It can be less number. Oh. Now let yes, now let kindly takes up 73 Act once. That kindly takes up 106 clause 3.
Yes, page number 2. Headmaster's manual with that?
Yes.
Volume 1. No, headmaster. It will be in volume 1 or 2?
Must be in the volume 1 because it's primary.
Volume 1? West Bengal Secondary Primary Education.
First page.
Oh, education manual.
Volume 1.
Volume 1. Yes.
Now kindly take some 106 clause 3. Since I have made submission that they are basically supplanting the existing rules by introducing this new impugn policy. And I said that cannot be done. But I'll try to demonstrate how the rules are framed. It's not to let. Now kindly takes up clause 3. All rules made under this act shall be laid for not less than 14 days before the state legislature as soon as possible after they are made, and shall be subject to such modification as the state legislature may make during the session in which they are so laid. Any modifications of the said rules made by the state legislature shall be published in the official gazette, and shall, unless some later date is appointed by the state government, come into force on the date of such publication. Therefore, it's not mere laying down before the legislature. There can be modification by the legislature after laying down before the legislature. That is the way how rules are framed. Therefore, the transfer policy is existing in exercise of power under section 106.
Yes.
Therefore, supplanting this policy, which is contrary to the transfer policy, cannot be done without following this procedure prescribed under 106. Now, in fact, on the similar facts, several cases were filed before the Allahabad High Court. It was reported in 2024 SCC online, Allahabad 7229. Kindly straightaway takes up the facts at paragraph 4 and 5. Petitions have been filed challenging clause 3, 7, 8 and 9 of the government orders dated 26 June 2024, as well as similar clauses indicated in circular dated so issued by Basic Education Board. The aforesaid government orders and circular have been issued purportedly in terms of the Right to Education Act 2009 and the rules framed by the state government in 2011. Thereunder, whereby proceedings have been initiated for fulfillment of pupil-teacher ratio in accordance with the schedule prescribed under section 19 and 25 of the Act of 2009. Then paragraph 7, clause 7 of the government orders provides that such shifting of teachers would be effected by transferring teachers on the basis of their length of service in a particular district as per their date of appointment under the principles of last come first go, whereby the junior most teachers would be shifted out first. Clause 8 of the government order indicates that by and large the same factor of last come first out principles but also requires the benchmark to be determined by taking into account the number of Shiksha Mitra contractual teachers available in this school. Then state at paragraph 14.
Yes.
14 kindly takes up paragraph 50.
50.
50. Yes, no, kindly takes up from 48. A perusal of the aforesaid conditions indicated in the impugned clauses of the government order does not indicate any reasoning as to why aforesaid principle is required to be followed for transfer adjustment of teachers in order to adhere to pupil teacher ratio in accordance with the schedule of section 19 and 25 of the Act of 2009. It is quite evident that by introducing such a concept, a classification has been made by the opposite parties pertaining to those teachers who have been posted in a particular schools longer than others who have been posted there subsequently. In order to address challenges to the policy, it would also be apposite to refer the judgments. I'm not reading. Then kindly takes up 49 and 50. Thus, judicial review of the policy decision can be interfered with only in case the policy framed is absolutely capricious, not informed by the reasons, or totally arbitrary, offending basic requirement of Article 14 of the Constitution of India. Then, paragraph 50 is important. In the present case, it is apparent that a classification as indicated here and above has resulted due to applicability of the principles of last in the first out as per the impugned government order and circular. As already noticed, no reasoning whatsoever has been indicated either in the government order or in the circular for such a classification to be effected. The aspect of reasonable classification has been enunciated and explained by the Supreme Court in so and so cases, and it was held that for any classification to survive the test of Article 14, it should be based on intelligible differentia having a rational nexus to the object sought to be achieved by law. Then my kind takes up paragraph 55. However, perusal of section 19 and 25 indicates only the aspect of maintaining pupil-teacher ratio as per schedule. The ostensible purpose of such norms and standards to be maintained is clearly that no school or class is deprived of a teacher in accordance with pupil strength. It is also discernible that there is no provision incorporated in the Act of 2009 or the rules framed thereunder for transfer adjustment to be made in keeping with the norms prescribed under the schedule by transferring junior most teacher of the school district. If the aforesaid procedure prescribed under the impugned clauses is kept intact, the real purpose or effect of such a condition would entail frequent transfer of a junior teacher in accordance with the Rule 21 of 2011 rules, that's the amendment, while keeping intact the posting of senior teachers for all times to come, since a teacher after transfer and joining in other districts would ipso facto remain a junior. The condition, therefore, is clearly not in accordance with the real intention and the purpose of the Act of 2009 and the rules framed thereunder. Such a classification also does not adhere to the test that it should be based on any intelligible differential, since no such intelligible differential has been indicated either in the government order, the circular, or even the counter affidavit filed by the opposite parties. Furthermore, the procedure as indicated for the last in first out also does not appear to have been rational nexus with the object sought to achieved by the Act of 2009 and the rules framed thereunder. Then, paragraph 60. This is very important, apropos to my first submission. Another aspect which is required to be taken into consideration is that executive order can only supplement statutory provisions, the purpose of which it purports to further, but it can neither supplant nor override such provision as has already been held by the Supreme Court in so and so case.
Yes.
As I submitted, that 2009 Act was introduced not for the purpose of transfer, rather to reach every people to ensure their education. Now, people should kindly take up the impugned policy once again, paragraph page 60,
Yes.
clause D. For determination of surplus teachers of a school, the teacher younger in biological age shall be considered first. This has been addressed by my other seniors. However, the second part, any willing senior teachers may opt for being considered as surplus teacher. Now, who are seniors? Not explained, not defined, vague. Therefore, this is arbitrary and creates class amongst themselves. Now, kindly takes up in support of my submission. I'll be placing a judgment. 1989 supplementary 1 SSC.
Supplementary page number
1989.
Supplement 1989 supplementary 1 SSC 116. May I read and
under the copy. Read which paragraph?
paragraph 19. 19 and 20 .
Read.
But then the process of classification is in itself productive of inequality. But then the process of classification in itself productive of inequality. Paragraph 19.
Yes.
The process would be constitutionally valid if it recognizes a pre-existing inequality and acts in aid of amelioration of the effects of such pre-existing inequality. but the process cannot in itself generate or aggravate in its inequality. The process cannot merely blow up or magnify insubstantial or microscopic differences on merely met- metric, metricious or plausible difference. The overemphasis on the doctrine of classification or any anxious and sustained attempts to discover some basis for classification may gradually and imperceptibly deprived of the article of its precious content, and the end is replacing doctrine of equality by the doctrine of classification. The presumption of a good faith in and constitutionally of a classification cannot be pushed to a point of predicating some possible or hypothetical but undisclosed and unknown reasons for a classification, rendering the precious guarantee of equality a mere rope of sand. To overdo classification is to undo inequality. The idea of similarity or dissimilarity of a situation of persons to justify classification cannot rest on merely differentia, which may by themselves be rational or logical, but depends on whether the differences are relevant to the goals sought to be reached by the law which seeks to classify. Justification of a classification must needs therefore to be sought beyond the classification. All marks of distinction do not necessarily justify classification irrespective of the relevance or nexus to object sought to be achieved by law imposing the classification. The classification that they are creating among the seniors without defining who are seniors will ultimately create inequality amongst themselves. That cannot be the object to be achieved by the state.
Yes.
That's all. That's all.
She will continue it. I will only take 10-15.
After the recess. Wait a minute. Yours is item number 4. Item number 4.
Item number?
State who is for item number 4?
Melody.
No, no.
Mr.
Strategy is it.
3 and 4 I have read.
3 and 4.
Yes, my lord, yes. My lord, these matters, my lord, let them complete. My lord, I will require a couple of days, my lord, in the interim, my lord, to respond, my lord, also. My lord, I would also, my lord, since they've challenged, my lord, an SOP, my lord, will be praying subject to, my lord, what my lord decides, my lord, to file also, my lord, put our stand on record, my lord.
That you will put, but they are pressing for interim order.
Yes, my
We'll
lord. As
definitely
per-
hear on the interim order thereafter we can see.
But on the interim order, my lord, as far as my lord will decide that, my lord, whether SOP at this stage, my lord, at the inception, my lord, the policy, my lord will be pleased to stay, my lord.
For the timing, my lord, SOP should not be, my lord, implemented, my lord.
Whether,
Let them come with the affidavit, my lord. We have no, my lord.
whether, my lord, at this stage, my lord, it is permissible. My lord.
Because they have started, my lord, giving terms.
এই বইটা দিয়ে দিন না ভট্টাচার্য সাবমিট করছে
এখন না দুটোর সময় তুমি হ্যাঁ এখন তো একটা করলো খাওয়া খেতে টেতে কাউকে দিবি না না আমি ভাবলাম ভুল ভাবিস না
Mr. Dasgupta, there are two rules we'll take after that.
Lord, in this matter, I am appearing on behalf of the alleged contempt, my lord.
No, to call no.
First of all, I am praying
Why she
unconditional.
has not appear
Appearing for item 36, requesting for a short
after
pass.
service of the rule? Why she has not appeared? Why the police has to be intimated to bring her before this court?
My lord, due to change of political scenario, there was some adverse situation in the locality, my lord, as well as the executive assistant and the secretary was confused with the order, as because in the order, my lord was pleased to direct the Pradhan to consider the representation at the 26th May 2023,
Yes.
which was not available with the Panchayat office as well as in the record of this case. And most dangerous was the change scenario in the local political scenario.
What is the notice was issued for hearing?
Now the proceeding has been initiated.
Where is the
Next
copy of the
date is
notice?
11th August is the date fixed for hearing.
Okay.
My lord, order is at page 66.
What is her name?
My lord,
What is the name? What is her name?
Promila Murmu.
Ashu.
My lord,
Promila Murmu, Pradhan Sultanpur Gram Panchayat. Alice Contemner is present in court. Learned advocate representing the alleged contemner submits that the process for compliance of the order of this court has already been initiated. Any notice has been received by you?
May I submit one thing, my lord? The last occasion when the hearing was held at the premises of the Sultanpur Gram Panchayat, a spot investigation report was handed over to me. My lord, kindly peruse the same. Already the issue has been settled by them after the hearing. Two issues was that the construction was made upon the land which was wrongfully gained. And second one is the construction was legal or illegal.
Illegal.
It is illegal.
So let them pass a formal order and file a compliance report. Thereafter, it will be proceeded to the SDO for taking steps in accordance with 23.
Kindly give it directions upon the SDO.
So
Otherwise,
let the orders be passed. They say that it is a process. So let it be come before this court by way of an affidavit of compliance.
yes,
You will process. He seeks to file affidavit of compliance on the written letter 2 weeks per date appearance. The appearance of the alleged contemner is dispensed with for the time being. You file the affidavit of compliance along with a copy of the order that is to be passed in due course. 18th August, 2 p.m. 2 p.m. 2 p.m. 18th August.
18. Well, kindly give some more time as because
he is showing that spot inquiry has been held. Now you have to pass an order.
Inquiry has been contacted and notice has been issued. Notice has been issued. Notice for hearing has been issued on 11th. Well, thereafter, the discovery of the meeting, crux of the meeting will have to be placed before the board of members. They will take the resolution as per statute.
Okay.
Some more time is required, my lord.
21st. 21st August. Next. 21st August.
Grateful to you. Well, personal appearance may be dispensed with.
Already done.
39, my lord, I beg to appear on behalf of the
alleged contemner.
My lord,
Here also, my lord, the same things, my lord.
My lord, we have comply order of this honorable court, my lord. My lord, as per your lordship order, 30 June, my lord, there was liberty on alleged content, my lord. In this rule proceeding, my lord, we can comply your lordship order, and we have comply your lordship order, and it has also sent as per section 23(5) of the West Bengal Panchayat Act to the SDO Kanla, my lord.
It is
And I'm
raised in
handing
by
over
way of an
one
affidavit.
copy.
Where is the alleged contemner?
My lord, see here, my lord.
The alleged contemner, Suma Maji, Pradhan Putsuri Gram Panchayat, is present. Mr. So-and-so, learned advocate for the petitioner, submits that, alleged contemner submits that the order of this court has been duly complied with. It has to be forwarded or forwarded already? Forwarded?
My lord.
Where is the
Yes,
forwarding?
yes, my lord. I have forwarded, my lord.
Where
SDO
is the-
Kanla, my lord.
Where is the forwarding?
Forwarded letter is not annexed with this compliance report.
You were
My
not
lord, I have annexed mail.
complied with, huh? He seeks to file affidavit of compliance. Let the affidavit of compliance be filed. আজকে কত তারিখ? Next week মঙ্গলবার দিন। File affidavit of compliance next week, annexing all the documents. Give advance copy to Mr. Chatterjee. Huh? 11th August, by way of an affidavit, that compliance will be filed by you, as well as together with the forwarding letter.
My lord.
And the appearance of the alleged contemner is dispensed with for the time being.
My lord, contemner is dispense from personal appearance, my lord.
For the time being, yes.
My lord.
Good.
সহদেব মতো আসো
Petitioner Jyoti Prakash Chatterjee.
My lord, your lordship has been placed the SOP. My lord, the first heading of the SOP says rationalization of, my lord, page 17, rationalization of surplus teacher. My lord, any rationalization should not be irrational. It has to be rational. Now, my lord, I would say this whole concept of surplus teacher, deficit teacher is a, my lord, vague term, because, my lord, according to me, my lord, there cannot be any surplus teacher. Cannot be. Why, my lord? The concept of surplus teacher, my lord, as has been taken by the state authorities in terms of the, my lord, pupil teacher ratio. My lord, the pupil teacher ratio is stated in the schedule. My lord, your lordship knows any schedule to an act cannot, my lord, run independently. It is in aid of the particular act of or provisions. My lord, if your lordship kindly comes to the Right to Education Act.
It is here.
The schedule, my lord.
Yes.
My lord, the schedule, below it is stated, see section 19 and 25. My lord, let us read section 19, my lord, for your lordship. Section 19, my lord. Norms and standards for school. Norms and standards for school. No school shall be established or recognized under section 18 unless it fulfills the norms and standards specified in this schedule. My lord, now subsection 2, where a school established before the commencement of this act does not fulfill the norms and standards specified in the schedule, it shall take steps to fulfill such norms and standards as its own expenses within a period of 3 years from the date of such commencement. So, my lord, what this, and my lord, it says section 25. Thereafter, I will come. My lord, now kindly see section 25. Pupil teacher ratio. Within 3 years from the date of commencement of the act, the appropriate government and the local authority shall ensure that the pupil teacher ratio as specified in the schedule is maintained in each school. Subsection 2. For the purpose of maintaining the pupil teacher ratio under subsection 1, no teacher posted in a school shall be made to serve in any other school or office or deployed. My lord, I stop here for a moment. Shall not be posted in any other school for the purpose of maintaining pupil teacher ratio.
No, no, no. Complete the sentence.
Yes.
Or any non-educational purpose.
Office or deployed
For any
for the educational purposes, non-educational purposes. My lord, deployed, when a teacher can be deployed, that has been enumerated in section 27. Except in census work or election work, a teacher cannot be deployed in non-educational purpose. And a teacher cannot be posted in any office or, my lord, in any school, deployed in any non-educational purposes. That is together. Now, my lord, why I am saying this? An act is to be read in its entirety. Now, my lord, kindly come to section 27. What does it say? 26 rather. Filling up of vacancy of teachers. The appropriate authority in selection to a, in relation to a school established, owned, controlled, or substantially financed by, my lord, so and so, by the appropriate government or the local authority shall ensure that number of teacher in a school under its control shall not exceed 10% of the total sanctioned strength. My lord, this presupposes that my lord, what the schedule prescribes the bare minimum. Otherwise, this filling up of vacancy would not have arrived commensurate to the sanctioned strength. My lord, your lordship knows, my lord, every post in a government institutions, my lord, must be sanctioned for an appointment to be made. So, my lord, if there are 10 sanctioned posts, a vacancy shall not exceed more than 1. If there is vacancy, it has to be filled up. Now, my lord, what the authorities are working on, that the pupil teacher ratio for 60 students, the teacher's requirement is 2, and that is more than 2, it's a surplus. It cannot be, my lord. Because, my lord, if that be the so, then 2 has to be read as maximum. If 2 is read as maximum, then, my lord, the whole scope of Right to Education Act will be defeated, because if a figure is maximum, I can be less than that. But a figure, if a figure is minimum, I cannot be less than that. Suppose, my lord, if 3 teachers for 60 students, the third teacher is considered to be the surplus teacher, then, my lord, it has to be constituted that 2 teachers are the maximum permissible limit or the maximum sanction strength that can be appointed. So, my lord, the authority then has the liberty or has the, my lord, power to appoint 1 teacher for 60 students. Then, my lord, the very scope of Right to Education Act will be defeated. So, my lord, what now lordship kindly comes to the schedule. Schedule says under section 19 and 25.
Probably the surplus, what you are defining surplus is showing that this is not the maximum limit. This is the minimum limit, you say. Minimum limit. In that context, for rationalization, to have minimum teachers in all these schools, they define it as surplus. That doesn't mean surplus means you cannot scale over 2. Minimum is 2.
So grateful to you. That is the point I was harping on. My lord, that means, my lord, a school may have 3 teachers for 60 students. That doesn't mean that the third teacher is a surplus. But, my lord, where suppose there are 60 students and there are 1 teacher, then the authority has to, from somewhere, has to meet up that second teacher.
Yes.
And now the question is, my lord, the mechanism and determination of surplus. Mechanism and determination. My lord, what the authorities has proceeded with, that only the schools having more than, I'm giving only 60 example for, my lord, in a school where there are 60 students and 2 teachers, the third teacher is a surplus and that school has been named in the surplus list. One teacher is surplus. Second, my lord, they have proceeded that in a school, suppose there are 340 students. In case where there are 200 and more students, my lord, the RTX prescribes that there shall be an head teacher and the pupil teacher ratio shall not exceed 40. Kindly come to, my lord, the schedule. My lord, the last one, above 200 children.
Yes.
Pupil teacher ratio excluding head teacher shall not exceed 40. That doesn't mean, my lord, it has to be 40:1. It means shall not exceed 40. Now, how the authority has proceeded? Authority has proceeded for 340, 10 is the minimum requirement, 40:1, and the remaining 14 teachers, suppose there are 14 teachers and the remaining 4 teachers are surplus. This cannot be. My lord, because it shall not exceed 40. Below 40, nobody is surplus. My lord, what I am submitting, the mechanism of surplus determination is itself faulty. My lord, in the present writ petition, my lord, there are, this petitioner was appointed in 2014. Now there are presently 46 students and 3 teachers. Now, my lord, my school, this petitioner school, has been put in the list of surplus school. Why? Because they are following as if 60 is the bare minimum and there should be 2 teachers. Third teacher is there and he has been shown as surplus teacher. And why petitioner has, before your lordship, petitioner is younger in biological age. My lord, younger in biological age, I will come later. My lord, so my lord, the very mechanism of surplus determination is faulty. It cannot be. What has fallen from your lordship, my lord, I bow down, this is absolutely correct. Third teacher is not the surplus, but where there is one teacher, this appropriate government will take steps so that to meet up that bare minimum of 2 teachers. Secondly, my lord, now what is the minimum requirement? RTX says for recognition, this is the pupil teacher ratio you have to maintain. Now, my lord, a primary school runs from pre-primary, class 1, class 2, class 3, class 4, class 5. So, my lord, a school to be run simultaneously, 6 teachers is a bare minimum in every school. Otherwise, my lord, suppose if there are 60 students and 60 students are distributed from pre-primary to, my lord, class 5, where the age group is, my lord, around 5 to 12, a class will be left completely vacant, my lord, completely vacant. And other teachers, we don't know what the students will do. Even they can go outside of the school, so and they will not be what the right to education prescribes, my lord, compulsory education. Compulsory education means, my lord, every student has to be taught. Now, my lord, if there are 2 teachers for 60 students distributed from pre-primary to, my lord, class 5, no students will get. I can demonstrate, my lord, if one class will be deprived of education every day. How? My lord, a primary school, a day primary school runs from 11 o'clock to 3:30. Half an hour, my lord, minimum half an hour is the recess time. So, my lord, it comes to 4 hours. So, in 4 hours, if there are 2 teachers from pre-primary to class 5, my lord, 2 teachers cannot teach all the 6 classes every day. One class has to be left out.
Yes.
No.
অনেক
So, my lord, the basic mechanism of surplus determination is faulty. There cannot be any surplus. The term should be a deficit in a school. No school is having a surplus teacher because, my lord, whatever a school teacher is appointed can be appointed in a school or posted in a school by two means, my lord. One through appointment or another through transfer. So, my lord, suppose in a school, if there are sanctioned strength of 10 teachers, so, my lord, all appointments within 10 sanction strength cannot be said to be surplus because the government has thought that a sanction strength is required and accordingly that particular sanction strength has been approved. So, my lord, any teacher, whether on transfer or whether on new appointment, is posted in a school cannot be said to be a surplus. What it can be said that a school has a deficit teacher, but no school has surplus teacher. Now, my lord, if a school has deficit teacher, now, my lord, section 26 I have placed before your lordship says, filling up of vacancies. This is a mandate of the Right to Education Act. Why, my lord? Because deficit cannot be fulfilled, my lord, by transfer. There has to be new appointment. My lord, if appointments are not being made and deficit are being filled up by transfer, it cannot be, my lord. This is barred by the Right to Education Act. Now, my lord, if a teacher is within the sanction strength, he or she cannot be termed as surplus. Because, my lord, when an appointment is made, my lord, today an appointment is being made, I chose a school because there is a sanction strength, advertisement has been made. Now, after my appointment, a notification comes that you are surplus, you are transferred. This cannot be done. My lord, these are my submissions on mechanism. Now, my lord, as far as this determination of surplus, if at all, let us presume the best case for the respondents. My lord, your lordship is with the respondents that there is surplus every after two teachers, third teacher is a surplus, and my lord, this SOP is tenable in the eye of law. In all such cases, now the question will come, my lord, determination of surplus. My lord, determination of surplus has to be, my lord, in terms of the last join. Because, my lord, suppose two teachers are already appointed, a third teacher has been appointed in a school, thereafter the ratio exceeds. So, first two teachers cannot be made to suffer for the appointment made by the authorities by appointing the third teacher. So, has to be the, my lord, the last teacher joining the school. If at all, my lord, this your lordships upheld this and everything, I would say there is no surplus concept in a primary school. There can be a concept of deficit teachers.
Yes.
Because, my lord, why I am saying this? My lord, with an appointment in a public post, my lord, the incumbent or the employee carries some right with it. One of such right, my lord, is a seniority right. Once I get an appointment, seniority, transfers are all incidents of that service. I carried with me, my lord, till my retirement and till my service tenure, the concept of seniority. Now, my lord, if this biological age is considered, my seniority rights are being prejudiced.
Yes.
My lord, now all this, my lord, I am making this submission on biological determination of surplus taking into consideration, my lord, your lordship is with the respondents and SOP and everything is tenable in eye of law. Because according to me, as I have submitted, my lord, there is no surplus. Now, my lord, if this surplus SOP is taken into consideration, my lord, your lordship has already seen it is an undated, unsigned document. Can, my lord, a constitutional court rely on such an SOP and, my lord, uphold such an SOP when there is no one to take responsibility of such an SOP? Now, my lord, let us take the best case for the authorities. This SOP has been issued in executive capacity and it has been signed. My lord, your lordship knows an executive does not have a power unless it is given to an executive to issue any notification or any order. It does not have a power on its own. It has to be given, it has to derive the power from somewhere. It has to be some rules or some act or anything. Now, my lord, if your lordship kindly comes to the Primary Education Act 1973. Volume 1, my lord. My lord, section 107. 107.
Primary Education Act.
Yes.
Your lordship, may I read? Power of state government to issue notification or order in place of making rules. So, my lord, at best, taking the best case of the respondents, it can be under 107. Now, my lord, I am placing 107. Notwithstanding anything contained in section 106 or elsewhere in this act, the state government may issue any notification or order or for carrying out the purposes of this act for which that government does not consider it necessary to make rules, or issue any notification order not inconsistent with the provision of this act in place of making rules under this act, if shall government consider it is necessary. So, my lord, this SOP relates to transfer. There is already an existing rule of 2002 which the government has deemed fit to, my lord, frame under section 106. So, when there is already a rule under 106 and that 2002 rules does not provide any power to the executive to supplement the gap in the transfer rules, my lord, this SOP is not tenable in the eye of
But the SOP, if it is consistent with the provisions of law, then 107, the government can invoke 107 and come up with a notification in the form of SOP.
My lord, provided, subject to correction, my lord, what is the subject? 107 talks about, my lord, if in this, if in that subject, my lord, the government feels not to make any rules. My lord, what my understanding is, if the subject is the transfer here, my lord, the government has deemed fit to promulgate a rule, my lord. So once the government has promulgated a rule, even if, my lord, there is a gap in the rule, some gap, my lord, it has to be meted by way of an amendment, not way of an executive instruction, because, my lord, executive instruction cannot override the rules.
Yes.
No, this is the 2002 transfer rules along with the amendment. My lord, if your lordship kindly see 2002 original rule 3 and how it has been amended. 162. Rule 3 says role strength in terms of Right to Education Act. So if it is terms, then cannot be any surplus. There can be deficit at most. There cannot be any surplus concept. And my lord, if your lordship goes to the rules, I am not placing it. There no authority has been given to the my lord executive to fill in the gap. My lord, in the absence of a rule, administrative instructions or GOs can be, my lord, made. But when there is a rule, if there is any gap, the only way out is the amendment. So, my lord, if I sum up my arguments, my lord, first, in primary sections, my lord, there cannot be any concept of surplus. There can be a concept of deficit, and that deficit has to be determined, my lord, considering the minimum requirement in a school. Where there is 6 teachers, in every school minimum requirement is 6 teachers, and my lord, that beyond that it can be considered, though my lord, Right to Education Act says appointment is the only way out if the vacancy exceeds less than 10%. And my lord, as far as the mechanism, my lord, I say that the mechanism they have followed, that is 40:1, 30:1 is the permissible limit, above 200, 40:1, that is not the correct mechanism, my lord. It will create more chaos. No, my lord, at present, this has to be, my lord, what mechanism they have followed, my lord, has to come by way of an affidavit, because some person has to take responsibility. My lord, in the meantime, if I or my learned seniors, my lord, have managed to make out a prima facie case, now, my lord, the balance of convenience is in our favor, my lord, because if the transfers are effected, there will create a chaotic situation all over West Bengal, and the entire writ petitions will be infructuous. Even, my lord, interim order, if granted, they let them come up with an affidavit explaining their stand. Otherwise, my lord, this entire effort and writ petition will be infructuous. I would pray, my lord, this SOP shall not be given effect to till your lordships hear out the deeply.
কি আছে স্টেটের who is appearing for item number 2 for the state.
For this state. My lord, Mr. Loknath Chatterjee was appearing.
In item number 2.
Yes, madam. Loknath Chatterjee.
লোকনাথ সব জায়গায় আছে, অনেক অনেক জলে জঙ্গল ধরে পড়ে।
Item number 2 for the state respondents. We received this matter very fresh yesterday only. Kindly give us some time so that we can take instructions.
Where is he? He was there. Item number 2.
অন্যদিন আমাদের কোনো আপত্তি নেই।
Who is for the state in other matters? Item number 3.
Item 3, Mr. Chaturvedi is appearing, and item 4, Mr. Chatterjee. 5, Mr. Chaturvedi. 5 or Chaturvedi.
Oh, Mr. Chatterjee has come. Yes.
Primarily, my lord, I have, my lord, sought for detailed instructions, but my lord, have not received them. But my lord, as far as, my lord, the issue of the Right to Education Act is concerned, my lord, the issues of in the scheme, my lord, which they are trying, my lord, to lay emphasis on, Right to Education Act, my lord, talks of, my lord, a minimum number. My lord, we will have to appreciate on what basis and under what circumstances, what was the objective, my lord, of coming up with the Right to Education Act. Well, the Right to Education Act, my lord, was a constitutional mandate, Article 21A, my lord, that had to be done, my lord, free and compulsory education had to be provided. So, my lord, there the resources of the state are strained. In those circumstances, my lord, to give a minimum number, my lord, of teachers, my lord, that was the ratio which was laid down, my lord, which has been stated as per, my lord, number of pupil teacher ratio has been given. My lord, the pupil, my lord, under no circumstances does the pupil teacher ratio, my lord, militate against the SOP which has been, my lord, brought about, and also does not go against, my lord, the scheme, my lord, of the Primary Education Act, my lord, which they are laying stress on. My lord, they have, my lord, as per what I find, my lord, it's only the Primary Education Act, my lord, on which they have, it's a primary my lord, school. So, my lord, under the Right to Education Act, my lord, up to 60 students, minimum number of teachers is 2. My lord, 61 to 90 it is 3, and my lord, 91 to 120, my lord, it is my lord, the schedule to the act, my lord, pursuant to sections 19 and 25, my lord. So, my lord, 91 to 120 is 4, 121 to 200 is 5, my lord, and above 150 students, 5 teachers and 1 head teacher. One of the scheme of the act of the Right to Education Act under the constitutional mandate is based on an entirely different thing, my lord, compared to, my lord, what is done here. My lord, here, if my lord will be pleased to take, my lord, the SOP, my lord, if I'm placing for my lord's kind convenience, my lord, the standard operating procedure. My lord, this I believe item 4, if I think he was arguing, my lord.
Babu. Item number 2 to only argue.
19857 টা শ্যামল কুমারটাই দিন তাহলে।
No, you are in 2. You are arguing 2. If you refer to 2, then we'll take up 2 only.
My lord, I am, since he completed with 4, I am starting. I'm sorry, my lord.
Oh, you are with 4.
My lord, 2.
So which brief are you?
4, my lord. 4. Shyamal Kumar. My lord, 2
Okay,
is
then
also
it's all-
there, but my lord,
In all of the writ petitions, they have an
it's a similar. My lord, so standard operating procedure in 4 is page 17, the Shyamal Kumar matter.
Yes.
My lord has that. My lord, if I may please. Standard operating procedure for transfer of teachers and non-teaching staff from zero enrollment schools and rationalization of surplus teachers. My lord, so that is the, my lord, nomenclature, my lord, of the standard operating procedure. My lord, I'm coming to the objective. To ensure optimal utilization of available human resources by rationalizing the deployment of teaching and non-teaching staff through the transfer of personnel from zero enrollment schools and schools having surplus teaching and non-teaching staff to schools experiencing a shortage of teaching and non-teaching staff as indicated by a high pupil teacher ratio. My lord, in my most humble submission, this is in aid of the Right to Education Act. This is in consonance with the Right to Education Act, not in disagreement with that act, my lord.
Yes.
My lord, the objective of the Right to Education Act is to ensure, my lord, that universal education is offered, my lord, to all students. And here, my lord, we are faced with a situation and a scenario where, my lord, for whatever reasons, there are, my lord, zero enrollment schools, thousands of them in Bengal, my lord. So these zero enrollment schools are there, and, my lord, schools having surplus teaching, non-teaching staff. So, my lord, the objective, my lord, as we can find, my lord, from the standard operating procedure, is for rationalization of this. So, my lord, in zero enrollment schools, so what it means, my lord, is, so there are no students, teaching and non-teaching staff are there, my lord, they are having to be paid. My lord, for what purpose? We do not know, my lord, their primary objective is to impart education. And, my lord, there are areas and places, my lord, where there is a shortage, my lord, of teachers.
Yes.
My lord, shortage of teachers, my lord, in the rural areas. My lord, shortage of teachers, my lord, in the non-urban agglomerations. My lord, no, in the non-suburban areas, my lord, there is a, my lord, gross shortage of teachers, my lord, and non-teaching staff. My lord, only Right to Education Act, my lord, solely looking at it is not enough. My lord, we will also have to look into the midday meal scheme, my lord. My lord, there are students, my lord, through this scheme, my lord, also the midday meal, my lord, is offered to students, my lord, who come to schools. So, my lord, along with this educational objective, my lord, there are other laws, other regulations, other schemes in place, my lord, which have also to be addressed through the school system.
Yes.
My lord, through the school system, my lord. So, the objective, my lord, I believe, my lord, in my most humble submission, the petitioners cannot have any quarrel with this objective, my lord. My lord, now I'm coming to the next portion, but my lord, as far as the objective is concerned, my lord, and if there are surplus, my lord, then if one is receiving, my lord, aid and assistance from the government also has its obligation, my lord, to ensure education reaches everyone till the age of 14 years, my lord. That's the mandate, my lord, of the Right to Education Act. This is in aid of that mandate. My lord, if in areas where the pupil teacher ratio falls short, my lord, because that is the objective, the last line of the objective, my lord, says experiencing a shortage of teaching and non-teaching staff as indicated by a high pupil teacher ratio, my lord. So therefore, the Right to Education Act mandate, my lord, to in order to give it greater effect and to ensure that it reaches the last person, or rather the last student, my lord, that is the objective of this, my lord, SOP, my lord. So there, just because I am a teacher, I am holding on to a position which is close to my house, my lord, I cannot claim to have any vested interest and vested right to stay there. There, my lord, I join issue with them. There I say they do not have any vested right. They cannot claim to have any right to be in a place of their choice. Because, my lord, we are also guided by the Right to Education mandate. We will have to ensure, my lord, the schedule to the Right to Education Act of 2009, my lord, the pupil teacher ratio which is there, it is ensured, my lord. My lord.
Yes.
Now, my lord, if I may place, my lord, the scope. This SOP shall apply to all government-aided sponsored schools under the administrative control of the School Education Department, except special school rule schools, and shall cover teaching staff in zero enrollment schools, my lord. This is important. My lord, teaching staff in zero enrollment schools, non-teaching staff working in zero enrollment schools, my lord, surplus teachers identified in schools where staffing exceeds the prescribed norms of the RT Act 2009, minimum required staff patterns in secondary schools. Secondary schools, my lord, is not an issue here. I'm not, my lord, joining issue on that. So, my lord, vis-a-vis the first 3 points of the scope, my lord, teaching staff working in zero enrollment schools. So, zero enrollment schools, which teacher, my lord, has a vested right, my lord, to say there are no students there, and then they will ensure, my lord, that very well, my lord. We are on the scope of the SOP. My lord, just in order to appreciate the scope of the SOP, my lord, so therefore the objective is zero enrollment schools. They cannot have any vested right or interest there, my lord. Non-teaching staff, my lord, in zero enrollment schools, there cannot be any vested right, my lord.
In the primary school, there is no non-teaching staff.
Very well, my lord. Thanks to the jack in the box who keeps popping up. My lord, surplus teachers identified in schools where staffing exceeds the prescribed norms of the RT Act 2009. My lord, where is it said? Where does it appear that it is, my lord, not in consonance with the Right to Education Act? Or, my lord, there is a quarrel with the Right to Education Act? It is in order to aid the aims and objectives of the Right to Education Act, ensure the conditions in the Right to Education Act, my lord, are maintained. So, my lord, we do not see, my lord, any quarrel. It is in furtherance of the Right to Education Act, my lord. If I may be permitted to, my lord, use that phrase, my lord. My lord, the procedure. My lord, identification of schools with zero enrollment having teaching and non-teaching staff. My lord, the procedure is in a very objective manner. It has been laid down, my lord. Which has been done. Identification of teaching and non-teaching staff in those zero enrollment schools, done. My lord, I'm also, my lord, looking into the scheme as a whole, my lord, SOP. My lord, we cannot look at it in a piecemeal manner, my lord, the way the petitioners want it to be looked at. It has to be looked at from a holistic perspective, my lord, in my most humble submission. One cannot pick and choose, my lord, a few lines from the SOP, my lord. My lord, 3, my lord, identification of schools with surplus teachers. So 1 and 2 are done. 3, my lord, is an ongoing as per the SOP, the 10 July 2026. Identification of surplus teachers. So, my lord, looks at, my lord, the objective parameters and the objective procedure in which they are proceeding, my lord. They are proceeding, my lord. First, they are identifying schools with zero enrollment, having teaching, non-teaching staff. Next, my lord, they are looking into, my lord, identification of teaching and non-teaching staff in those zero enrollment schools. My lord, it's a waterfall mechanism which is coming down, my lord. In a very objective manner, they are proceeding. My lord, then identification of schools with surplus teachers. Identification of those surplus teachers, my lord. Then, my lord, identification of schools with high PTR, my lord, pupil teacher ratio, having deficit of teachers, which means, my lord. So this is important, my lord. My lord, clause small Roman 5, my lord. Identification of schools with high pupil teacher ratio, which means there is a deficit of teachers. My lord, the district authority.
How many right now are zero enrollment schools?
My lord, that those instructions I've sought for them, my lord. Exactly, my lord. I've not yet received them, my lord. If I may be given a couple of days, my lord, I will definitely, my lord, revert to with those instructions, my lord. My lord, those statistics, my lord, I've sought for, my lord.
SOP does not disclose so.
SOP says done. My lord, SOP will not get into, my lord, the figures. My lord, in case, my lord, it is my lord's pleasure, my lord, I will.
Okay, continue.
My lord. My lord, the DI secondary and DPSC for primary shall publish a list of schools having teacher shortages, which is a high pupil teacher ratio, indicating school name, district, block, circle, number and category of teachers required, including subject in case of secondary HS schools. So, my lord, here we are not, my lord, met with secondary school teachers here. My lord, so therefore, district DI will, my lord, DPSC rather, will publish a list of schools having high pupil teacher ratio, which means there is a shortage of teachers. And, my lord, what is to be indicated is also stated. My lord, identification of staff for transfer. All teaching and non-teaching staff posted in zero enrollment schools shall be considered for transfer.
Yes.
My lord, logically there cannot be something against it, my lord. Teachers who are already placed on deployment may be transferred to the place schools if required as per pupil teacher ratio. My lord, surplus teachers from other schools shall also be identified. For determination of the surplus teachers of a school, teacher younger in biological age shall be considered first. However, any willing senior teacher may opt for being considered as surplus teacher. This is in bold, my lord. And I believe, my lord, they also have something to say regarding this, my lord. For secondary school, subject-wise surplus teachers would be considered. So, my lord, if I may, my lord, this point 7, teaching, non-teaching staff in zero enrollment schools will be considered. Teachers on deployment may be transferred if required as per pupil teacher ratio. Surplus teachers from other schools have to be identified. And, my lord, for determination of surplus teachers of a school, teacher younger in biological age shall be considered first. Any willing senior teacher may opt for being considered as a surplus teacher. My lord, here, to give an example, my lord, everyone, my lord, has experienced or has experienced in situations, my lord, where in government jobs, transferable positions, my lord, people are given, my lord, their positions closer to home, my lord, at a senior age. So when you are young, you are supposed to travel. When you are young, you are supposed to be amenable and open to transfer. So younger in age, my lord, that is the principle which is applied, my lord, in any employment of this kind, my lord. This is, my lord, a general idea, general knowledge, my lord. Anyone who signs up, my lord, or has dealt with government jobs, my lord, or quasi-government, my lord, positions.
Okay. Yes.
My lord, next, my lord, secondary schools, subject-wise surplus teachers would be considered. My lord, if my lord is pleased to take the next page. For primary schools with low pupil teacher ratio, the concerned HT would not be considered as surplus teacher for transfer, being head of the institution, as there is no specific subject-wise post of teachers in primary schools. For determination of the subject teachers of a school, teacher younger in biological age shall be considered first. Now, my lord, here again they have, my lord, one logic of biological age which I have placed, my lords, for before my lord, for my lord's kind consideration. My lord, there has to be a rational basis and objective which criterion which has to be developed. My lord, in my most humble submission, my lord, there should not be, my lord, any objection, my lord, to an objective criterion, my lord, which has been devised in the sense, my lord, younger in biological age should be considered. My lord, so this is in my most humble submission, this is an objective criterion, and against this objective criterion, my lord, there cannot be, my lord, this. So my lord will be pleased to consider that an objective criterion, they may like it, they may not like it. There may be, my lord, 10 other options which one can come up with. My lord, senior, my lord, junior, one may be senior in biological age, but my lord may be junior, my lord, in as per, my lord, employment, years of employment. There can be. My lord, there can be 10 plausible explanations, but if the explanation or the logic, my lord, or the objective which is contained in the SOP, my lord, is also tenable, it is also plausible, my lord will be pleased to consider that, and not, my lord, consider 5 other plausible explanations which may be there, 5 other, my lord, plausible, my lord, grounds which can be there, or conditions which can be laid down. My lord, whether it is rational or irrational, my lord will be pleased to consider. They will have to demonstrate that this condition, my lord, of biological age is not something which is, my lord, rational. They will have to demonstrate it is an irrational classification. That, my lord, in my most humble submission, they have not come up with. They have not demonstrated before, my lord, that this classification is not in terms of, my lord, the Right to Education Act, not in terms, my lord, of the primary education law, and, my lord, is an irrational classification. That is the hurdle and burden, my lord, which they had to discharge before my lord's court. My lord, the modalities for transfer. Identified surplus teachers shall be given an opportunity to submit their preferences from amongst the published list of high pupil teacher ratio schools within the stipulated timeline. So, my lord, they are being given, my lord, an option. Depending upon the application submitted by the surplus primary teachers, DPSC will take necessary further measures for transfer of such teachers in schools with high pupil teacher ratio having deficit of teachers. My lord, so the overarching objective, my lord, in my most humble submission, my lord, is, my lord, the high PTR is something which is playing in the mind, my lord, of the department at all times, my lord, of the commission, my lord, of the authority rather. Wherever there is, my lord, a high PTR and a low PTR, that is, my lord, the overarching objective, my lord, which appears throughout this document, my lord, being the standard operating procedure. My lord, first is identification of surplus teachers. Then, my lord, depending upon the applications. So, my lord, they are being given an opportunity to submit their applications. DPSC is to take further measures. My lord, for secondary level schools, the teaching and non-teaching staff posted in zero enrollment schools, along with these identified surplus teachers in schools with low PTR, will submit their preferences from amongst the published list of high PTR schools within the stipulated timeline to the concerned DI secondary education, who will then compile the same and submit the proposal to the, my lord, commission for further course of action. My lord, here they are not, my lord, from secondary education, but nonetheless, this forms part of the SOP. Many schools which were upgraded in the last 10-15 years do not have any sanctioned posts, but all such schools are in dire need of teachers for the particular categories. Transfer of teachers from zero enrollment or low enrollment schools may be considered with post to schools with high pupil teacher ratio or in need of particular subject teacher with post. My lord, this is very important, my lord. This is somewhere, my lord, I will draw my lord's kind attention to. Many schools which were upgraded in the last 10-15 years do not have any sanctioned posts, but all such schools are in dire need of teachers. My lord, what is the object? My lord, the school education system exists for the teachers only, my lord, or for the students? This is a question, my lord, I asked to myself, my lord. My lord, so it is entirely, my lord, the contention of the petitioners is entirely, I am a teacher, consider me, my rights, this is in contravention. But what about the students, my lord? What happens to their education? What happens to the mandate of the state, which is to provide education to the students, my lord? Where does that go? My lord, so this overarching objective which, my lord, emanates from this entire document, my lord, is schools are in dire need of teachers for particular categories. Transfer of teachers from zero enrollment to low enrollment schools may be considered with the post to the schools with high PTR or in need of particular subject teacher with post. It is, my lord, in aid of education, my lord, and for the students, my lord. This entire system exists, my lord, if I may be permitted to say, my lord, for the benefit of the students, my lord, not for the teachers solely, my lord, if I may say. Transfer orders, my lord, E. shall be issued as far as practicable based on the options exercised and administrative requirements. Again, my lord, a lot of, my lord, emphasis, my lord. First, my lord, is being given, my lord, to the students. Then, my lord, teachers give options. Come up with options. We will give, my lord. They have, my lord. It is not the case, my lord, that we have given these options and my options are not being considered. My lord, there are two bases on which, my lord, it has to be considered transfer orders. My lord, point E, my lord, at page 18. My lord, based on the options exercised and administrative requirements. Now, my lord, they can come and say that the question of, my lord, administrative requirements has not been, my lord, done in a fair manner. That can be, my lord, that they will have to demonstrate. It is not their case, my lord. So the first is to be given, my lord, importance is to be given on the options exercise, my lord. By whom? By the teachers, my lord, and administrative requirements. My lord, if a surplus teacher fails to submit preferences within the prescribed period, or if the preferred schools cannot accommodate the teacher due to limited vacancies, the competent authority shall assign the teacher to any identified high PTR school based on administrative exigencies and educational need. Now, my lord, again the
Clause E, which you have indicated, clause E.
My lord,
there is a procedure laid down in Rule 5 itself, which is to be followed upon an application being made by a school teacher.
My lord.
Again, a clause has been you have incorporated a clause which says that based on the options and administrative requirement.
My lord.
But 5 gives an entire aspect of the procedure to be adopted by the council for transferring. If an application is made, what are the criteria to be? So this is an additional.
My lord. This, my lord, whether, my lord,
that the administrative requirement and options which is already in the rule, you are again bringing a phrase clause to section Rule 5 of that.
Yes, my lord. So this says transfer orders shall be issued as far as based on the options exercised and administrative requirements. My lord, now as far as, my lord, the rules are concerned.
Come to Rule 5.
My lord, there are these. More data. Lord, I'll just speak. Yes. So, my lord, I understand what has fallen from, my lord. Rule 5 যাচ্ছে।
Can also transfer. This is a step towards.
My lord, so, my lord, in this case, my lord, if I may, my lord, also submit before in my most humble submission, my lord, the power of the council, my lord, is not taken away. So the power of the council to effect transfers, that remains. 5 is there, Rule 5. So if I may be permitted to say, my lord, that the power of the council to effect transfers gives the council, my lord, gives the authorities also to come up with, my lord, or to incorporate this within, my lord, the SOP. So this power of the council does not get denuded, my lord.
SOP nowhere records that. Nowhere records that the transfer rules of 2002, this is in addition to that. Then we'll reflect to that, because if you come to Rule 5,
4A also
begins with the clause that 4B has to be complied with. Now, if you take a junior teacher, suppose he has qualified in 2025, the approval has not yet come, but the SOP says that you transfer the junior teacher for rationalization. So, Rule 4B will be a bar. But if you follow the SOP, there is no such bar. You can transfer any teacher who has joined in 2025 without approval. You cannot, without approval, you cannot transfer as per rule. But this SOP says that yes, you can transfer because he is the junior most teacher of that school. Can that be made?
My lord, also, my lord, this has also to be, this is one, my lord, issue which I will have to, my lord, satisfy, my lord. The other issue, my lord,
I have followed you, because RTE says that the schools have to be a minimum of teachers.
Yes.
Upon survey, the government has come to this conclusion that there are schools where there are zero enrollment, the teachers are not functioning or they are not they cannot function because they are not students. So their service has to be put in some other schools where there is deficit.
My lord. My lord.
But I am on to this that you have to rationalize on the basis of the existing rules that is there. If you say that this SOP is an addition to that and is not in contrary to the existing rules, then it will show that if a teacher joins in 2025, he is not at all approved, then where does he go?
My lord, here the scheme of the SOP, my lord, demonstrate that this should not, my lord, take effect on a permanent basis, my lord. The scheme of the SOP, my lord, because this is the identification. So this, my lord, follows a one-time process. That, my lord, is which is, my lord, this identification also, this does not say, my lord, this identification will be done periodically every year or in some. So, my lord, this from the looks of it, my lord, appears to be, my lord, a one-time process, my lord, where this rationalization is to be done. My lord, this is not a permanent process, my lord, which will take effect, my lord, every time. One cannot take, my lord, refuge to rationalization. My lord, this is evident, my lord, from a perusal of the scheme. My lord, so E, my lord, whether rule 5 and E, my lord, this is something which I will, my lord, try and, my lord. So if, my lord, if surplus teacher fails to identify, then, my lord, the authority will do it, my lord. My lord, transfer orders G will be issued, my lord, by the competent authority. Zero enrollment schools are having, my lord, all sanctioned posts. All such posts may be withdrawn at the state level with appropriate orders to utilize those posts for the schools where needed. So, my lord, this is also, there cannot be any, my lord, quarrel with this, my lord. In the instance of closure of schools for transferring the teacher and non-teaching staff from zero enrollment schools to any other schools, concerned SI schools will take over charge as custodian and immediately inform, my lord, the status of physical assets. My lord, so this is, my lord, in
What is
my lord,
in the page 19 annexure P3? What is this they have annexed?
My lord, that is something, my lord, they have annexed, my lord. This is whether, my lord, I've this document, my lord, whether it's a complete document.
Mr. Dasgupta, what is 19?
In 19 takega?
19 complete list of activities. My lord, in district Purulia, this is the list of schools which have been termed as surplus schools. I have only annexed my page, my lord. This is the document. There is no notification or forwarding letter.
Okay.
This is the school, my lord.
How many teachers are surplus? This has been indicated.
This has been indicated.
Oh, okay. Yes, Mr. Chair.
My lord. My lord, now, my lord, in secondary, my lord, this rationalization is not the first time this is happening, my lord. In 2023, my lord, there was, my lord, the guidelines were published, my lord, 216 SE of 10th February 2023 with respect to, my lord, rationalization in secondary schools, my lord. That was already effected and done, my lord, in 2023. My lord, as far as primary schools are concerned, my lord, that notification did not apply, my lord. So, my lord, essentially, my lord, this was done by the Commissioner of School Education on 10th July 2026 for rationalization of teachers primarily, my lord, in primary schools. My lord, essentially, my lord, the Commissioner of School Education has the prerogative, my lord, to, my lord, frame and communicate guidelines for the authorities to conduct the rationalization process, my lord. To, my lord, the objective being the overall pupil-teacher ratio, my lord. My lord, there is, my lord, no express policy, my lord, of the state, my lord, for pertaining to guidelines, my lord, for rationalization of teachers in primary schools. So this is why, my lord, the state had to come up, my lord, with these, my lord, guidelines, my lord, and the authority, my lord, is not something, my lord, which has to be.
But then you are following the subsequent one or both are prevalent as on date?
My lord, a rationalization again, my lord,
there are two SOPs.
My lord, one is of 10 July 2026.
So government is following the subsequent one or the earlier one, both are prevalent?
My lord, there was on 2023, my lord. That was for prime.
There are two guides. They are shown in the morning. There are
166. Item number 5 and 6, both the SOP.
5 and 6 ta apna
5 ta daw to.
Is the subsequent one which I have.
Yes, then both are prevalent as of now or only the subsequent ones?
But my lord, 10th July, I have been told, my lord, 10th July issued by the Commissioner of Schools is, my lord, so whether both are, অন্যটা কোথায় আপনার কাছে আছে? ওটা আমি মানে না জেনে বলতে পারবো।
দাও না 5টা দেবনাথ বাবু, আইটেম নাম্বার 5টা দিন না,
অন্যটা ডেট
5 বা 6টা দিন তো।
10ই জুলাইতে চিঠিতে বলছে দুটো ইস্যু প্লিজ আসবে এবার পড়ে নাও কিনে নাও না না লেখা আছে কখনো রিভাইজ হওয়ার পর দেয়নি না সেটা আমার ডিভাইস চলছে
এটা দিয়ে দুটো পাওয়া যাচ্ছে।
এই কোথায় একটাই
রিপিটিশন পেজ 164 দেখো 164 আর 166 আমাদের তো টাইটেন 6 দিয়েছে তো 49 এটা আর 49 সুবিধাটা দিস না
একই তো
একই না না এটা চেঞ্জ
কি চেঞ্জ 10 জুলাই দুটো
বায়োলজিক্যাল যে ফ্যাক্টরটা আছে না সেটা সেকেন্ড ওইটা আর কোনো চেঞ্জ বাকি সব কিছু চেঞ্জ আছে বায়োলজিক্যাল এজ বায়োলজিক্যাল
7D, there is a change in 7D. Now 7D of the previous one, it has also recorded once noting that it is pertinent to note and mention that there are no provisions in existing rules. Now the subsequent one, that sentence has been deleted and the entire process
biological
to
younger in
identify the
biological
surplus
age has
teacher
been
has been changed. Now, which one is prevalent today?
ইনস্ট্রাকশন দিয়েছে আপনাকে কিছু এটা নেই my lord, in the instructions which I have received, they advert, my lord, to younger teacher, younger in biological age shall be selected.
So the
as first-
subsequent one, subsequent ones.
Yes, that is what I am, my lord. In the instructions which I have received, my lord, clause 7D, it has been stated that teacher younger in biological age shall be selected as first surplus teacher.
দেখতে দে না না আমাদের
হ্যাঁ কপি নিয়ে নেবো নাকি
আরে দেখতে দে না কি বল
এত লাফালে হবে
there are two
my lord 7F also there is the biological age has been introduced once.
You are holding which brief read
My lord, I am holding the one which Mr. Biswas just handed over to me.
It is 19893.
My lord, 19903.
19903. যাও যে ওটা যাও।
না না জশাবের কাছে কোনটা আছে
I am with 19893 of 2020. This is
এটা এটা না
Nistha Devnath.
yes Mr. Devnath is item number 5
তাহলে এটা এটা
এটা দেখো এটা
My lord, it's the my lord I've seen my lord. There
No. What I am into is there is a letter of the chairman which has been annexed to that writ petition. It the paragraph starts with all sub-inspector of schools are requested.
page
Page 163 of that.
এটা না জশাব এটা দেখাচ্ছে এটা দেখ
না কিছু করতে হবে না কটু আছে
দেবো খুলে দেবো
দিয়েছি
বাবা এত উদার কবে থেকে হলো
কপিটা দাও
বাবা জীবনে দেখিনি এত উদার হতে।
দেখো এই ফার্স্ট আর সেকেন্ড দুটো একসঙ্গে রেফার করা আছে জশাব এটা জিজ্ঞেস করছে এখানে দুটোই যখন রেফার করা আছে
ইয়ে
তাহলে কি দুটোই অ্যাপ্লাই করছে
First and revised SOP.
So the persons who have filed their application at the time of the first prevalent of the first SOP, that rule will apply in case of those persons. After a cutoff, an application has been filed, for them the revised SOP will apply as per this letter. Is it so, Mr. Banerjee?
Lordship, I have no instruction.
But then how do you apply the SOP then?
I will.
Lordship, let him complete. We will follow him linear.
First SOP, within send the received transfer applications from zero enroll temporary posted and willing surplus teacher as per first SOP within today, and send the remaining received transfer as per revised SOP.
So clause D of 7 is
D and F.
is not equally applicable to all the persons.
Yes, D and F, both introduce biological age.
So there you
There is something, my lord, as far as
differentiate between the date of application.
date of application.
Any other submissions? You
Lord, as far, my lord, I'll take instructions, my lord, on those points, my lord, I will address, my lord.
yes, then Mr.
Yeah, my lord.
You are in item number
But I am in item number 5, the brief that my lord is holding.
19893.
My lord.
Oh. এটা আগে থেকে সান্নাল সাহেব এটা
My lord.
Yes.
Lord, 574 persons, my lord, have joined together. They all belong to and serve under the No.24 Pagnas District Primary School Council. Wait. Now,
Yes.
my lord, I do not see that in respect of service matters which are individual in incident, my lord, there is any jural relationship inter se between any of the petitioners or altogether all the petitioners cumulatively. In the absence of such jural relationship, whether, my lord, the parties joining together in this writ petition espousing a common cause can be entertained in invocation of prerogative writ jurisdiction or not.
Yes.
The issue is no more res integra, my lord, a coordinate bench. Lord, pass an order, my lord. Justice, Honorable Justice. Yes. Kindly permit me to read not the first paragraph. 310 individuals claiming to be unemployed youths, having registered their names in the concerned employment exchange, have joined together to file the instant writ petition, praying inter alia for a writ of or in the nature of mandamus to issue the respondents their agents and servants, particularly the DPSC Malda, being responsible to rescind, cancel, withdraw the entire selection process for the post of primary school teachers under the jurisdiction of so and so. In this context, my lord, kindly sees paragraph 4. After considering the submissions made by the learned advocates for the parties and upon perusing the instant writ petition, it appears that the writ petitioners had submitted their documents and testimonials along with biodata forms before the DPSC on diverse dates. There exists no jural relationship inter se the writ petitioners. The only common thread of joining as co-petitioners appears to be the status of being unemployed youths whose names were sponsored by the concerned employment exchange for recruitment to the post of assistant teacher in primary schools under the DPSC Malda. In my opinion, having regard to the facts and circumstances as stated above, this is not enough for the writ petitioners to join together as co-petitioners and instituting the instant writ proceedings in the absence of any jural relationship between them. In the case of Mota Singh, the Supreme Court was considering the question of whether legally payable court fees could be evaded by truck owners who simply joined as co-petitioners by stating in their petition that they were plying trucks for export of goods and had a liability to pay the tax impugned. The Supreme Court, while rejecting the office to scrutinize afresh each of the cases referred to in the office report and ascertain whether requisite court fee had been paid in respect, also observed inter alia, it is too much to expect the different truck owners having no relation with each other, either as partners or any other legally subsisting jural relationship of association of persons, would be liable to pay only one set of court fees simply because they have joined as petitioners in one petition. Each has his own cause of action arising out of liability to pay tax individually, and the petitioners of each one would be separate and independent petition, and each such person would be liable to pay legally. It would be a travesty of law if one were to hold that as each one uses highway, he has a common cause of action with the rest of the trucks. Then, at this stage, it may not be out of place to refer to a division bench judgment of this court. In the case of Parul Devnath, the court, while considering an appeal preferred by the writ petitioners who were working as home guards in Andaman Nicobar organization, on the facts of that case observed inter alia that there was no need to direct the 130 writ petitioners to pay court fees for each of them, since it had not been held by the learned single judge that all the writ petitioners were not entitled to join in one petition. The division bench judgment, in my view, is wholly inapplicable, since the learned single judge in that case had not held that 130 persons were not entitled to join in one petition, whereas in the facts and circumstances of the instance case, there is simply no existence of any jural relationship inter se the petitioners as observed. So I am, my lord, at the moment raising an issue of, my lord, absence of any jural relationship inter se the petitioners, which would permit them to join, my lord, as co-petitioners. I am not as much on a curable defect of, my lord, permitting the petitioners to put in the deficit court fee and then espouse the cause, my lord, of as raised in the writ petition together. Now, the second, my lord, limb of argument, my lord, that I make would be on merits. My lord, what is the subject matter of challenge here, my lord, is possibly, my lord, has lost, my lord, its significance amidst, my lord, the hue and cry of the councils who have traveled far beyond, my lord, the scope and ambit of the subject matter in challenge. The subject matter in challenge is, my lord, 10th July 2026, whereby and whereunder the Commissioner of School Education has permitted that each of the district primary school councils, my lord, to rationalize. Now, this rationalization, my lord, is not, in my humble understanding, my lord, equivalent to the apprehensions, my lord, which have been raised of being transferred to a distant place, being otherwise aggrieved. Transfer is only a consequence of this rationalization.
Yes.
There would be two things. when I challenge the policy to rationalize, I have to see whether the government is competent and empowered to rationalize or not. Is the very concept of rationalizing, Milord, vitiated by any mischief, Milord, any malice in law? If not, if it is not for attaining any oblique objective, then merely because, Milord, as a consequence of this rationalization, some persons, Milord, will stand to be affected. Milord, the policy of the government, Milord, cannot be faltered. The power cannot be faltered. Milord, the SOP, Milord, has been shown to my Lord by each of the councils and also by my learned friend, Milord, appearing on behalf of the state, Mr. Chatterjee. I would not, Milord, trouble your lordships with that once again. But the relevance, Milord, thereof would be only in respect of, and in my understanding, Milord, the holistic understanding would be there are schools, Milord, where, Milord, there is zero attendance. There are schools where there are surplus. In view of upgradation, there are schools where, Milord, the teachers, there is deficiency of teachers. The process of rationalization is only going to deploy, Milord, the teachers in a rational manner. Transfer is only an incident of this process of rationalization. It can be nobody's case. None of the teachers can say that I cannot be transferred. None of the teachers can say that even if the school where I am studying, teaching, it has surplus staff, I cannot be the subject of this rationalization process. But if that be so, then, Lord, the decision-making process, the decision to rationalize, Lord, is beyond any cavil of doubt of being, Lord, issued under competent powers. Lord, kindly, Lord, for a moment takes up page 163. This is, Lord, 10th July 2026.
Yes.
But this is, Lord, the genesis. This is where, Lord, from where everything stems. Lord, kindly sees, this is issued by the Commissioner of School Education, the Government of West Bengal School Education Directorate, Primary Education, from the Commissioner of School Education to the Chairman, District Primary School Councils. And the subject is rationalization of primary school teachers.
Yes.
And what is Lord called upon? Hereby requests him her to take immediate measure for rationalize primary school teachers in accordance with RTI Act 2009. On urgent basis by transferring teachers from school where teachers are surplus as per PTR of the school to the schools where number of teachers are deficit as per PTR of that school. I say this directive is in compliance of a statute. This spells out to be so, that this exercise is being undertaken in consonance with the intent and spirit of the Act of 2009. And the district primary school councils who are otherwise blood fit and competent under the rules to transfer, they have been asked to do it. Now, Lord, kindly sees page 163.
Yes.
163, This is not an instance of North 24 Parganas. But the district primary school, the chairman district primary school council, in compliance with page 162, Milord, is inviting Milord, options from the willing senior and junior teachers of the schools within particular dates. And then Milord kindly sees Milord, the SOP Milord is enclosed. So my lord would see, my lord, who is undertaking the exercise of transferring, but the exercise is being undertaken by, my lord, the council. Now, my lord, kindly comes to the rules. Kindly comes to, my lord, page 168. These are the rules, my lord, relating to transfer. At the risk of repetition, my lord, I say that the process is for rationalization. Transfer is incidental, for which SOP is being issued. SOP, among other, also deals with transfer, and it is being now implemented by an authority who is otherwise competent. For that, I take my lord to page 168. Now, my lord kindly sees 4A. Lord, condition for transfer.
Yes.
The council may on its own motion. So it is not, my lord, that the council on its own motion cannot transfer. The transfer can only happen at the instance of the applicant or of an incumbent. Now, to implement this SOP, the council has invited for option at the same time. This is, my lord, on its own motion in terms of 4A. In terms of 4A, now, my lord, kindly sees that if any of these 574 persons, my lord, who is transferred, he is aggrieved by it, whether the statute gives him a remedy or not. Kindly sees, my lord, page 170. Kindly sees rule 10. A teacher aggrieved by an order of transfer may now kindly sees, my lord, 10(2). Such an aggrieved teacher shall, before preferring an appeal against an order of transfer under these rules, be required to comply with the order of transfer. So this is where the shoe is pinching. Rationalization, I have not heard much, my lord, that 10th July 2026, my lord, has been challenged, saying that the government does not have the power to rationalize. Now, if government has the power to rationalize and to manage, my lord, the teachers under its control, then it has to deploy. Now, this deployment would be in the form of transfer from a place from where there is a surplus to a place where there is a deficit. And this is in consonance with the rules. And once this happens, Lord, he has a remedy under Lord 10, but he has to go. The challenge has today been thrown with regard to not as much, my lord, the process of rationalization, but to the effect of its implementation, that it will entail transfer, and each one will have to go and join, and each one will have to prefer an appeal thereafter. So why not club together, file a common cause, say that the entire process is bad? But this issue of mass transfer of teachers fell for consideration, more particularly Rule 4A, before a coordinate bench. One teacher came up and challenged the process of transfer of about more than 300 teachers. Well, the court held that the council has the power to transfer, and in such policy decisions, the court would not interfere. This is 2022 SCC Online, Calcutta 769. Prasad Kumar Shamanto. 2022 SCC Online, Cal 769. ও কি আকাশ থেকে ফেলে দেন, যেটা এয়ার ড্রপ না কি বলে দাও, করে দেবে। Kindly sees paragraph 1. The petitioner is a primary school teacher. He is aggrieved by the transfer order dated so and so, issued in favor of the chairman, in his favor by the chairman. The petitioner has been transferred from so and so school to so and so school. Now, my lord, kindly come to paragraph 14, my lord, straight away. It has been submitted that the order of transfer was passed by the school education department, not in respect of the petitioner alone, but in respect of 390 teachers for the interest of primary education to maintain the student-teacher ratio of primary school. The said decision was taken for rationalization of primary teachers to ensure proper distribution of teachers among different primary schools in the state by way of transferring primary teachers from schools running with surplus teachers to the schools having deficit teachers. It has been submitted that the services of the petitioner is transferable and he has been transferred within the same circle where he was serving, not relevant. It has been submitted that according to the provisions of law, there is no bar in transferring teachers on the basis of the number of years that he has put in. The school education department published a list of so-and-so teachers who were surplus in their schools, and accordingly they have been transferred en masse. It has been denied that there was any malafide intention while issuing the order of transfer in favor of the petitioner. It has been contended that it is for the employer to decide when and where to post an employee for extracting best services from him. The respondents rely on the judgment passed in so-and-so, wherein the Honorable Appeal Court was of the opinion that the teacher belongs to a noble profession and he has a very rigorous responsibility of laying the foundation by enabling character and morals in the young children. The teacher has more responsibility than any other person in the society, and he has to make sacrifice even at his own inconvenience for building up a strong nation. Then 18 also relies upon a judgment in Joginder Singh, wherein the court had held that it is entirely for the employer to decide when and where and at what point of time a public servant is transferred from his present posting. Ordinarily, the courts have no jurisdiction to interfere with the orders of transfer. Then, paragraph 21 refers to rule 20. I have heard and considered the rival submissions made on behalf of the parties. The petitioner, being a primary teacher, is guided by the West Bengal Primary Education Transfer of Teacher Education so-and-so rules 2002. Rule 4 of the said rules lays down the condition for transfer. It mentions that a council may, on an application from a teacher, transfer an approved teacher within its jurisdiction from one primary school to another primary school on the condition that such approved teacher is confirmed and has completed minimum 2 years of continuous service. It further mentions that the council may, if it considers necessary for a proper utilization of service of primary teachers in the interest of education, transfer an approved teacher without maintaining any time limit of service. Without maintaining any time limit of service. It was, my lord's query, as to whether any time limit is prescribed or any manner is prescribed as to who should be transferred first. The rules, are silent on that, but there is a bar with regard to transfer. I shall come to that. The said rule further mentions that where there is a surplus teacher according to roll strength, the council may, on its own motion, transfer such approved teacher without maintaining any time limit of service by way of rational adjustment of teachers in a primary school. So, what is, oh, Lord, paragraph 23, my lord. As of now, there is no provision in the service rules of primary school teachers that the transfer can be made on the principles of last come, first go. On the contrary, the transfer rules prescribe that transfer of approved teacher may be made without maintaining any time limit of service for proper utilization of service in the interest of education. Relying on the aforesaid rule, the petitioner was transferred, the same is certainly. It is settled law that an employee whose service is transferable do not have any vested right to remain posted at a particular place. It is for the employer to decide when and where to post a particular employee for extracting best services from him or her. Transfer being an incident of service, courts ought not to interfere with the same in a casual manner unless there is reasonable inference or malafide action pleaded in the petition. The order of transfer ought not to be interfered with. Lord, this Lord takes care of Lord two things. One, that the action taken is in consonance with the rules. Lord, the rule, Lord, has vested Lord the council Lord with the powers to transfer, and the rationalization policy is leading to culminating in Lord transfer, which again, Lord, if until unless shown to be Lord smacked with any malafide, Lord, would not be interfered merely because Lord a personal inconvenience is being caused Lord to any of the teachers. Lord, insofar as the policy, I'm sorry, insofar as Lord the policy decision of government is concerned, the courts Lord are always Lord slow to intervene and interfere in it, Lord, because it is Lord exclusively within the domain of Lord the executive, how it Lord manages its affairs. Lord, today, Lord, all of us are before my Lord because of Lord, the precarious condition that the system of primary education of the state is in, where Lord, there are teachers, Lord, who are sitting and gossiping because they don't have students to teach. There are students who are sitting and playing and making pranks because there are not sufficient number of teachers. So this imbalance, Milord, is sought to be addressed by the Milord, by the government. Milord, this Milord cannot be Milord seen to be Milord vitiated with any Milord oblique motive. Milord cannot Milord be seen to be Milord without any rationality. Milord, this cannot be termed to be arbitrary. This cannot be termed to be unjustified. This cannot be termed to be irrational. Then, Milord, I put a question to myself, Milord, as to why, Milord, my Lord's prerogative jurisdiction, Milord, would be invoked. Milord, kindly permit me to cite 2006 volume 10 Supreme Court cases, page 337. And my Lord would kindly not come directly to paragraph 11, which would be, my Lord, at page 7. But the pagination, my Lord, would get at left-hand side top, my Lord, in very small letters.
Yes.
Paragraph 11. While exercising the power of judicial review of administrative action, the court is not the appellate authority, and the Constitution does not permit the court to direct or advise the executive in the matter of policy or to sermonize qua any matter which under the Constitution lies within the sphere of legislature or the executive, provided these authorities do not transgress their constitutional limits or statutory powers. হয়নি পিটিশনটা গল্প হয়ে গেল Now, my lord, kindly, my lord, permit me to pause here for a moment. My lord, I say, which of the SOP clauses of SOP, my lord, are found to be, my lord, in contradiction to what the objects that is sought to be achieved, qua either the RTE Act or qua the rules of 2002 which permit transfer. Blood, in my humble understanding, 10th July 2026 not only spells aloud that it is being done for complying the provisions of 2009 Act, and the enabling provision for transfer, my lord, lies in the 2002 rules, my lord, 4A, which I showed to my lord. Now, the scope of judicial inquiry is confined to the question whether the decision taken by the government is against any statutory provision or is violative of the fundamental rights of the citizens or is opposed to the provisions of constitution. Thus, the position is that even if the decision taken by the government does not appear to be agreeable to the court, it cannot interfere. Lord, with deepest of respect, if I may say, my lord may not agree, my lord, with the manner in which this rationalization is being done. My lord, as human beings, we all have, my lord, opinions. Lord, my lord may opine that there can be a better way of doing it. There may be an alternative means which will cause lesser inconvenience. But then, if my lord is imposing that, or my lord is asking, my lord, the executive to act in a particular manner, my lord, then paragraph 11, in the beginning it says, then the court is harmonizing. The question is not, my lord, one of agreeing to the manner in which the executive functions. It is to find out whether this is impermissible because it smacks of arbitrariness, it smacks of irrationality. This cannot be permitted to be done. The correctness of reasons which prompted the government in decision-making processes, taking one course of action instead of another is not a matter of concern in judicial review, and the court is not the appropriate forum for such investigation. My submissions find being buttressed, my lord, in paragraph 6. The policy, I'm sorry.
Yes.
The policy decision must be left to the government as it alone can adopt which policy should be adopted after considering all the points from different angles. In the matter of policy decisions or exercise of discretion by the government, so long as infringement of fundamental rights is not shown, the courts will have no occasion to interfere, and the court will not and should not substitute its own judgment for the judgment of the executive in such matters. In assessing the propriety of a decision of the government, the court cannot interfere, even if a second view is possible from that of the government. Then, the court should constantly remind itself of what the Supreme Court of United States said in Metropolis Theater. The problems of the government are practical ones.
Yes.
And not like Mr. Sanyal's clients, individual ones. But these are my additions.
Yes.
The problems of the government are practical ones and may justify if they do not require rough accommodations, illogical, it may be, and unscientific. But even such criticism should not be hastily expressed. What is best is not always discernible. The wisdom of any choice may be disputed or condemned. Mere errors of government are not subject to our judicial review. Similar, the government, my lord, has decided, I would say, the object is pious. The object is pious to ensure that each and every corner of the state, it gets, there's a equal, we expect equi-distribution of monsoon, Lord, which is, Lord, the gift of nature. Lord, today, an endeavor is being made, my lord, to spread the equidistribution of education to each corners, my lord, of the state, and for that this endeavor, my lord, has come. I beseech your lordships, my lord, merely because, my lord, some persons, they, my lord, apprehend that the transfers may not be in consonance with their choices, or that some inconvenience, individual in nature, will be caused to them. But their apprehensions may be wholly misplaced, because uh, they may, my lord, stand to gain by these transfers, because it's all, my lord, in the womb of the future to see. But merely because, my lord, this apprehension is there, my lord, it is too early, my lord, to say, to judge that the entire process is smacked with such an arbitrariness or irrationality that it calls for an interference in, my lord, high prerogative jurisdiction of this honorable court. Those, my lord, huh? कौन सा? दिखा दिया. That's done. So, my lord, my first, my lord, limb of argument, the writ petition should be the writ petition, my lord, should be dismissed, my lord, in view of the decision that I have shown to my lord. Lord, even if, Lord, my lord, entertains the writ petition on merits, Lord, I say that these are, my lord, policy decisions, Lord, which do not smack of, my lord, any arbitrariness. My lord would not, my lord, pass any interim order, and, my lord, kindly direct, my lord, filing of affidavits. We have just been served with copies of the writ petitions yesterday in the evening. My lord, we had no time to seek instructions. Most of us, Lord, on the right side of the petitioners, they faltered in answering to my lord's queries, because, my lord, when by the time we got the petitions, my lord, we had no officers available in the office of the directorate to answer our queries. And in the morning, my lord, we came to, my lord, meet the arguments of, my lord, stalwarts, my lord, like Mr. Sanyal. So we had no time, my lord, to cope up with the array of bows that came to us. Writ petitions, my lord, should.
Thank you.
But my lord, just to add, my lord, if I may, my lord, small query which had fallen from my lord regarding Rule 5, my lord. My lord, just to address that point, my lord, Rule 5 is based entirely, my lord, on under, my lord, clause B of Rule 4, and which is, my lord, where the concerned teacher, my lord, makes an application himself or herself. And, my lord, here this is Rule 5 will not apply, my lord, in my most humble submission, because it relates only to Rule 4B. Here, my lord, we are under a case, my lord, of Rule 4A. There, my lord. So that is where, my lord.
I mean, for a
And
No,
my lord,
no, no. Because in your SOP you have given that they can give option. Giving of an option means he is applying for the
yes,
particular.
that option does
So
not.
it's not that on own volition the council is acting. The
Right.
option is also given to the teachers that you come up with an option which school you want. That's why I said that the transfer, as far as practicable, it says that arising out of option being given or for administrative reasons. Both are there.
Lord,
So on own volition as well as on an application made by the teachers giving an option that these 3 schools I am opting for. That is there. So 5 will come.
Lord, the exercise is under 4A. How I implement 4A, Lord, again, is, Lord, a discretion which, Lord, I, Lord, preserve with me. Until unless, my lord, it is found to falter with, my lord, any of the rules. I say that you go to this school, I am transferring you. Instead of doing that, since, my lord, large number of teachers are, my lord, in the process of being considered, and since it's the process of rationalization to cause least of inconvenience, we say, very well, I am intending to do this. You can, however, give your choices. Now, the moment I ask for choices, this does not automatically get relegated to 4B. I am still exercising in 4A, because 4B would be, without my asking, he comes and tells me that I want to go.
Yes, my lord. Yes, my lord. Just to add, my lord. So therefore, my lord, 4.
So 4A, my lord, is the power. The rationalization, my lord, is to be done. The commissionerate asks the councils to do it. Council exercises powers under 4A. But it, my lord, also seeks the convenience. This is, my lord, how the trajectory, my lord, of the entire process goes. My lord, have I been able to answer my lord's query? To the best of my ability, my lord.
Then 4 has a two aspects. One
Yes.
is of out of own volition and another is by way of an application. Now you're telling that exercising the volition by way of an option being also called
But
for
as
from the
I, my lord, submitted to my lord. My lord, kindly sees, my lord, 4B. My lord, on an application from a teacher, transfer approved teacher. My lord, here is a case where, my lord, the teacher is saying that I want to get transferred. He exercises an option. He applies. We will consider whether we can transfer him there or not transfer him. Give him a hearing at best. Now 4A. 4A, I can individually transfer him to another place. This is not a case of one individual. We are looking into our assets. We say the teachers are our assets. We are trying to manage our assets and we intend to put them to least inconvenience. So we say that surplus teachers, you give your options. We try to accommodate to the extent possible whatever option you exercise. But this asking for option does not relegate my action to 4B. It still remains to be under 4A. Right? I'm grateful to my lord.
Lordship,
আমি কিন্তু ওইভাবে হাই তুলিনি যেভাবে তুমি তুলছো।
As far as item 6 is concerned, my lord, my all points which I could give a reply is already covered by council and my senior councils as well. Lordship, one aspect only one I want to give it to your lordship for.
এটা দাও item number 6 টা দিন। Item number 6 টা দিন।
Lordship, we have to see today the issue is whether before I get a chance to controvert with my facts and figures, is this document under question is so irrational that it has to be immediately stopped giving any effect. We are all three are arguing today on a premise whether this is so irrational that has got an immediate bad effect on the entire system as a whole. It's not like that only one gentleman will be transferred by this or two will be transferred by this. So if your lordship really thinks that this required consideration, then lordship, we will also take instruction and we will come back to your lordship. So today, lordship, my seniors and the councils for the state has already given a direction that this is a arguable matter. It can be this side, this can be that side. But lordship, so far as the brief which I am holding, is there any one environment which shows that if it is not state today, then the consequences are this, or an irreversible state will appear? Because I have to only judge the situation. If it is not state, then what is the effect within coming 7 days? So, lordship, I have to see from the averment. The averment speaks about, now lordship kindly takes up 6 and the grounds therefore. If we now look into the grounds, very quickly we will go through the grounds once, lordship. Lordship will find none of the grounds are said which is per se affecting or leading a situation of mayhem condition. These grounds indicate that this provision may not tally with this. Lordship, if we just read it quickly, it starts from page 31.
Yes.
Lordship, kindly see, this ground talks about in elementary education, there is no teacher concept. So that then next 2N defines e-school. Then 3, 8D of the Act, duty cast of the appropriate government to provide infrastructure, including a school. I think this is, in fact, is for that the said norms and standard for the school such and such in respect of such and such. So this is also a fact. Then 5, one teacher unless we have to wait. Then Lordship kindly see the 6. The given situation where the respect of the school in paragraph 8, number of the student are below 6, but there are the student in each and every classes from primary to 2, but it is admitted number of teachers are taken 2, then there is no teacher to teach the student for the rest of the 4 classes. So Lordship, what now Lordship kindly turn to paragraph 8 of the.
Yes.
Now Lordship, paragraph 8, they have tried to demonstrate for the purpose of convenience, appreciation and perception of the contention and submission of the petitioner, best Lordship has got.
Yes.
Based on the fact with regard to this, the Lordship, they have said that this is the total strength, this is the assistant teacher, head teacher. Number of surplus assistant teacher is 2. Now they are saying, I have got a surplus assistant teacher. If you take that back, so situation is this. So Lordship, what they are trying to show is after implementation, something will happen this. There is no emergent situation. Now Lordship, kindly turn to the next. Roman 7, page 34. Then 8, first sentence. For that, per clause such, under the heading procedure of the SOP, head teacher is not considered as a surplus. This clause is entirely against the provision of this as such, and we read the provision such and such. So Lordship, then if we take the 9, which considerable in number of primary teacher in this, at least separate one classroom for every teacher does not physically exist, for example. See. So this is Roman 9. Lordship, that is talked about that. Then must be one special educator for such and such. So these are the things they are requirement, nothing to do with this SOP. Now Lordship, kindly 11. For that, to elaborate and advance the contention of illegality, arbitrary, malified, unconstitutionally of the SOP, the revised SOP will take the reference of such and such, such and such. For that, the revised SOP such and such under the heading such and such surplus teacher in the school are to be identified, determined such and such, the prescribed norm in case of the school such and such. The 2 assistant teacher out of the 3 and 1 such and identified as surplus for the reason that are admitted 39 students. That is to say that less than 60 students. Therefore, the said school is entitled to have only 2 assistant teachers. Fallacy is that the said cannot have a head teacher and their way. So, Lordship, what they are saying is, if it is at all implemented, what is SOP intended? Now, Lordship, kindly turn to the SOP. Now, Lordship, kindly see. Either you, Lordship, can come to 49A and 49C. To ensure optimal utilization of available human resource, which is submitted by my learned senior, that national development of teaching, non-teaching staff, the transfer of the personnel from 0 school such and such, surplus such and such, such and such, a shortage of this non-teaching staff indicated by high pupil-teacher ratio. The scope shall apply to all government such and such and shall cover teaching working in a 0, non-teaching this, surplus teacher this, minimum required of such this. Procedure, then identification.
Yes.
So, Lordship, what I am trying to show is, it is a procedure, administrative procedure has been opted to identify. Is it, I put this question to myself, is it not too early to understand that this is the administrative procedure, this will be executed, and then that will result to this anomaly? So, anomaly which my learned senior opponent friends tried to demonstrate is a system or a future which might come out of this. And come out of this is in what sense? It might lead to a situation according to them. If I even for a moment, if I feel that what they said is correct, then in the process may lead them to a situation. So can I halt that process today? I put this question to myself. But my learned senior, my counsel for the state has stated that give us 7 days time, we are coming back to it. So Lordship, they have to show that even 7 days is so grave that cannot be altered by the court. That case has not been made. I observed the hearing, I found that the final hearing on this issue is going on. We state has not received any chance to controvert them with my statistics and data. What is my thought process of publishing this? I have my objectives. I have my collective intellectual decision on the issue. I have not been able to place before you. So today when we are in an ad interim stage, they have to show that even 1 day sustenance of this SOP is so irreversible in nature. Lordship, I have tried to show from the document that this is not there. My second point is, if we take a further holistic view, the transfer policy, Haryana. Lordship, this optimizing policy, I will not restrict myself to see only this West Bengal. Whether this is there in other state or not. Lordship, this other states is having a same option. Assam, Haryana, Odisha, Andhra. This operating system, Lordship, today we are handicapped because yesterday that has been served upon me. So Lordship, I can show, if your Lordship give me a, not transfer policy, that optimal rationalization. So Lordship, if we take the state of Haryana, I have a transfer policy there. I have a optimism policy there. If your Lordship, laptop mobile, if your Lordship allow us even a evening's time, tomorrow morning, I can place this before your Lordship. So Lordship, then optimization of the resources is there in other states. The hue and cry which has been made today, that this has been done by the state of West Bengal and this is. So what I today say before your Lordship is, then this entirety of says 3 categories are being dropped out. Now let's go back to their issue. Head teacher, then option, which has been clarified by my learned senior, option, head teacher, and their preference. So if this particular document is taken, and Lordship, if your Lordship, which has been much argued by them, that is, if teacher in biological age, Lordship, teacher with the biological age. Lordship, that has been narrated by my seniors, but Lordship, kindly see the restrictions. If your Lordship see the rule, even after age of 57 and something, there is a bar on transfer. Just saying 57, 58, there is a bar on transfer. So the, which is submitted by my learned counsel for the state, that younger in age, more easier to adopt in a new place. Now, Lordship, when it was argued by Mr. Majumdar, he constantly said that this is in violation of a constitution, in violation of a national policy. I have shown, at least in my draft, my brief, there is no contradiction they have shown that this is against national policy. There is no one ever meant in the grounds they said that this is against the national policy. They have to indicate that this is the national policy which is in contradiction to this, and the effect is this. So far as pleading is concerned, because I am not in a position to controvert that pleading, pleading has to be enough clear before your lordship today.
Education has not been adopted by the state of West Bengal as of yet.
He argued, but that also he has not been. So, lordship, what he argued is also not reflected in the grounds. Now, lordship, kindly see the document which he has annexed at page 50. The West Bengal primary education, page 50, lordship, they have annexed it that if this is existing, then how that SOP can come. That was another limb of their argument. Now, lordship, kindly take 5, where this is applicable. 5.1. A teacher seeking transfer under the clause B of 4. Lordship has got. So, lordship, moment they talk about this is a teacher seeking transfer, and mine is for the optimization of the resources for a object. So here what they have annexed and say this is contrary. Lordship, do these two things hold a two different field. If your lordship just permit me, I can hand over this policy to your lordship. Haryana. আমার নেই গো, এয়ার লিফট এয়ার ড্রপ দুটোই নেই, আমার কাছে একটা অন্য ট্যাব আছে, হোয়াটসঅ্যাপ এটা ট্রান্সফার পলিসি, এটা একটা ন্যাশনাল পলিসিও আছে। তো দাদাকে এয়ার ড্রপ করো।
Which clause you are referring? Mr. Banerjee?
Yes,
which clause?
Lordship, I am just saying this clause are quite akin to this policy which is under challenge. I found my learned senior opponent are also ready with those. So, lordship, what I'm saying today is the concept introduced here is not a.
Yes.
The concept introduced here is not a alien to the knowledge of optimization. So what I'm saying is, we can come back to your lordship with our documents, and there is no emergent situation by which lordship can protect them, or there should be a interim order in someone's favor.
Later to what?
And then lordship, if your lordship kindly come to the prayer.
No, there was a last date fixed for submission of any option of that, anything of that sort.
6th August.
3rd August.
6th August. 31st July and 6th August.
6th August. Is there any date fixed for submission of any option, or?
I tell you, losses. The option comes later. First, identification of the surplus school and surplus teachers. That has been done in my by the council. So my right has already been affected because I have been declared either surplus or deficit. So on the basis of options, SOP says if I do not give options, they will take action. I'll have a look at this.
No, I'm coming, sir. Page 48.
48.
Yes.
Yes.
The sub-inspector of the school are directed to check, verify, and forward the received transfer application of the teachers to the undersigned by this.
Yes.
with their clear forwarding notes and official recommendation. Lordship has got.
Yes.
So, Lordship, what I'm saying is, as of today and for the coming 7 days, no case has been made out, because though they said it's a set aside, but basically from the argument it seems that they are challenging almost the constitutional validity or the virus of this SOP. Now the second question will be before your Lordship, which we will be arguing, is it an administrative direction or it is a constitutionally valid document which we are trying to look at? Whether it is in aid of a policy or implementation of a policy, or itself it is under any statute or rules or under constitution. If today we are talking about a constitutional validity, illegality, rationality, then the presumption has to be this SOP is pursuant to a statute. Judgment of paper. Lordship, judgment. Lordship, there is a plethora of judgment which says, if it is an administrative thing for a purpose, so there is no hurry either for the court, because administrative action, it can always be set back to its original position by the court of equity. So once the SOP is there, and which is, it's not a constitutional conformity document, not in conformity of the constitution, which may say that it might lead to a clash with the constitutional provision, might lead to. And I will try to show it cannot. It is just to implement it for a situation or to attain an object. As my learned counsel for the state submit, it might be for one time, it might be for the second time. It's an operation, because unless I do this, but I try to implement something, then the individual discretion of the officers come into play. What is the object of this SOP? The object of the SOP is not to have an independent individual prudence to implement. A collective measure to be taken in this methodology. So what we are talking about is SOP, this discriminates. That goes, if we goes to the more root of it, if we go to the more research of it, Lordship, we will. Yes, that's right. So Lordship, this SOP is a minimum standard procedure to be followed so that the discretion of individuality not come into the way. The very object of this SOP is
what the question which is going through my mind is,
yes,
what I also put to him, that you are placing SOP of two structures. One, you say that the subsequent one, you say that the junior most is to be transferred.
True.
Correct. That clause was not there in the earlier one.
True.
The principle which was there, that was different from what was made in subsequent. But they both are prevalent. Now, suppose for the sake of argument, if it is placed like this, that tomorrow you take out an SOP and say that the persons who have attained 30 years, they will be transferred. For rationalization, it is, the SOP says rationalization, but you fix a age, 30 years. What is the rationale behind that? Why the other clause, which was there in the earlier one, has been given go by in the subsequent one?
True. Very true.
And it also records, which I find from, if you have the copy, it says that there are no existing rules relating to such provision.
Lordship, that
subsequently that particular line has not been recorded in the coming SOP. We all know that there is no existing such policy how to make out a surplus teacher who will be transferred out of 4. If it is, for example, there are 4, who is to be transferred? So that is not there. But that particular noting of the earlier one is not in the subsequent one. And there is a change of the principle. So we might expect that the third SOP which will come will be having some other principles.
True.
I concede that for rationalization it is required because there is zero, so he is not discharging any function. So he has to go. But what about these principles which has been indicated in 7D? There is a change, and both the, as per the letter of the
7F.
chairman, both are prevalent. Both are prevalent. You apply for some set of the teachers, the earlier one, the subsequent you apply in case of other teachers. So what is the rationalization behind that?
Lordship,
As far as well,
Yes, Mr. Banerjee.
Lordship, now let's place it in a way they can pitch their case that high that there is no rationale in it. Now, Lordship, kindly see what is this SOP about. SOP is not about procedure to transfer. The very basic, my learned senior friends have pursued the SOP as if it is the procedure of transfer. I say the procedure of transfer will come later. This is the procedure of identification.
But under
Now, I'm coming. Allow me 3 minutes time. So, moment we think it is the procedure of identification, even if suppose Mr. X applied the first and he said such and such person will be, because he is not youngest, but he will be given, and another person says he will be youngest, so another council says Mr. X, and another council says Mr. Y is not the youngest, and here which comes from this council, they say he is the youngest, because this is the alumni that is falling from your lordship. This is the situation. Now, lordship, kindly see page 48 and 49.
tomorrow. We'll continue tomorrow.
Yes.
But then I take your answer tomorrow on the question which I have.
Yes, lordship. I will be
Again,
trying my.
it is the prerogative, remains the prerogative of the council to make a SOP and apply that.
Lordship, SOP.
Equally, it should be applied to all. Why then subsequent 2 SOPs? Come back tomorrow.
Yes, lordship. Yes, lordship.
My lord, item number 1, kindly take it.
I have been requested by many of my junior colleagues to record an order for today.
Yes, yes. Same orders, Sabha court, heard. Huh? The whole day it is going. First order, ending up to fix it for item numbers করে দেবে না? Item number 2 they heard Mr. Vikas Ranjan Bhattacharya, learned senior advocate, appearing for the petitioners. Mr. Item number 2 who appeared for the state, Mr. Chatterjee. Item number 2 who appeared for the state.
I am told and I'm appearing in 2 to 4.
I'm told.
2 to 4.
Please.
2 to 4.
Mr. Loknath Chatterjee, learned advocate, appearing for the state respondents, also places his points of argument. Please this matter tomorrow for further consideration. Last item number 6 se korbe Mr. Shiv Shankar Banerjee.
Lord, in item number 2, I am for the district primary school.
You give your name, that will be recorded.
Yes.
You continue with that. Kalke rekho, tomorrow.
2 PM, lordship. Kindly keep it at 2 PM.
2 PM, my lord, I believe my learned friends for the appearing for the state will take 2 hours.
No,
Then, my lord,
No, no.
it's below to Thursday.
We are facing
It's a pressing circumstance. 8 July notification clearly says that act on urgent basis transfer. That's the exact order.
First order রেখে দাও 11টার সময়
My lord, item number 1, kindly take it Friday. Maulay Bhattacharya cannot attend the court in this week, my lord.
Item number 1 was that prepared to assist you.
My
next Monday it will be taken. Next Monday te rekha.
Not except Monday. Except Monday.
Well, Mr. Shanna is not aware, but he will not be there.
Then on ওটা একটা অন্য ডেটে হিয়ারিং এ ডেটে না হিয়ারিং এর লিস্টে মঙ্গলবার দিয়ে অন টুইসডে
Yes.
এক নম্বরটা টুইসডে তে দেবে ফার্স্ট অর শেষ করুক অনেকটা হবে হ্যাঁ বিশুর ভট্টাচার্যের আগে বলে দিচ্ছি
AICQ Lordship, indulgence should I?
Yes.
But there is a madrasa matter which is urgent. Police is the list on every Wednesday it is appearing. There is some urgency.
Votes. On Friday, you mentioned it's sleep. Sure.